given existing law and jurisprudence. Consensus emerged to retain the revised Penal Code framework, Articles 166 to 170 were approved in principle, subject to style and discuss amendments. Sorry for that. The body also noted that express inclusion of government lottery is unnecessary given existing law and jurisprudence. Consensus emerged to retain, as I said, subject to style and discuss amendments, pending BSP written position paper on the scope of other instruments of credit and whether additional terminology is needed. Prosecutor Ciudadano was directed to submit proposed rewording clarifying connivance. Article 178, false medical certificate, false certificates of merits of service or service aids. Proposed revisions were largely stylistic with apparent penalty changes and deletion of or sojourn, close in open parenthesis. DOJ, Solicitor Soto and Nyopi Law, Professor Borja clarified that penalty differences stem only from nomenclature in the proposed criminal code draft and were not intended to reduce liability, both supported restoring the RPC penalty deletion of open parenthesis or sojourn close parenthesis was accepted given current medical regulations. Article 178 was approved in principle subject to style, deletion of or sojourn open and close parenthesis and restoration of the RPC penalty consistent with the policy of preserving graduated penalties for falsification offenses. Article 18, 181, perjury and counterfeiting access devices. These were already comprehensively covered by existing special laws. UP laws, Professor Liasos and the body agreed that inclusion would create unnecessary duplication without filing any gap or improving policy. The subcommittee approved deletion of Article 180 and 181 from the proposed criminal code without prejudice to continue the application of the relevant special laws. Counterfeiting drugs and related offenses, House Bill numbers 4374 and 5446. The proposal involves intellectual property, trademark, pharmaceutical regulation, and consumer protection beyond ordinary falsification. Attorney Louis Andrio C. Calvario noted existing special statutes administered by PDEA and others. Any criminal code incorporation requires careful study to avoid inconsistencies. The proposal was parked pending POPLHL formal position paper or appropriate statutory treatment in light of existing IP, public health, and consumer protection laws. Article 182, manufacturing and possession of instruments or implements for falsification or counterfeiting. The draft retained core elements but showed a penalty difference due to nomenclature. UPLO and DOJ agreed to restore the RPC penalty. Article 183, usurpation of authority or official functions. The body preferred oneself, open and close parenthesis, over open parenthesis, themselves, close parenthesis, for grammatical precision suggested by NSC's Attorney Isel D. Pangan, Penalty differences were again attributed to nomenclature. The RPC penalty was to be restored. Article 183 was approved in principle, subject to style, replacement of themselves with oneself, and restoration of the RPC penalty, Article 177. Article 184, using fictitious name or concealing true name. The draft largely tracked Commonwealth Act number 142 but omitted significant amendments from Republic Act number 6085. Broader exceptions, judicial authority for aliases, one alias limit, registration. Yopilos Attorney Stigoy presented a revised draft reflecting RA 6085. Ateneo's Attorney Harvey Bilang and DOJ Solicitor Soto favored a narrower approach, penalizing only concealment of true identity when disclosure is legally required, while allowing legitimate aliases, pseudonyms. The body discussed practical situations involving public personalities. The subcommittee approved Article 184 in principle, adopting the DOJ formulation, balancing state interest in individual liberty, and replacing and with or in the title in second paragraph to reflect alternative modes of commission. Copies of revised drafts were to be circulated. Article 185, illegal use of uniforms or insignia. PNP's Colonel Angelo Pueblos highlighted that Executive Order 297 prohibits unauthorized manufacture, sale, distribution of police uniforms, insignia, but lacks a statutory penal provision, creating enforcement difficulties. Ateneo's Attorney Bilang and DOJ's prosecutors Cristoria stressed that the revised penal code offense centers on public improper use with intent to deceive, defraud, facilitate crime, expanding to manufacture, sale, risk, departing from the chapter's structure, legitimate uses, films, theater, education under authorization should remain permitted. Congressman Romulo and Congressman Tino noted that manufacture, sale is a distinct act from improper use and could be addressed via an additional provision rather than altering the existing offense. Consensus retained the existing first paragraph, delete the phrase in the second paragraph, beginning open parenthesis, or with the intent to avail, close parenthesis, up to open parenthesis, otherwise avail, close parenthesis. PNP was directed to prepare a proposed third paragraph specifically penalizing unauthorized manufactures, sales, and use of uniforms of military and other uniformed personnel with corresponding penalty for the next meeting, which is today. Assignment, BSP, written position paper on the scope of instruments of credit under Articles 166, 170. Prosecutor Ciudadanos proposed rewording, clarifying connivance. PNP proposed third paragraph for Article 185, unauthorized manufacture, sale, use of military police uniforms plus penalty. Ipopil, position paper on counterfeit drugs as noted above. That's the end of what we had taken up last the hearing of this committee. So, Ask the ano. Can we now proceed with Article 186, Section 2, false testimony, while we are waiting for our regular chairman. Right?
False testimony in criminal cases.
Yan na din. Bagam. Muto.
139.
Okay.
Draft.
Yeah. Article 186, false testimony in criminal cases. Any person. Yeah. Now, any comment from the Department of Justice on this one? I am sure you have read the proposed amendment.
Yes, Your Honor. The amendments which we made here, so far as the title is falsification, false testimony in criminal cases, as contradistinguished with the title, false testimony against a defendant. We made this updating, Your Honor, it's all because defendant, as stated under the revised penal code, properly pertains to civil cases. Although in the last portion of the provision, it mentions criminal case. In order to clarify and to clarify the provision, we opted to just indicate false testimony in criminal cases, Your Honor.
Yes. Just to add to the point of prosecutor, thank you, Mr. Chair. Just to add to the point of Prosecutor Ricamora, we also purposely use the term criminal cases to indicate the fact that in this particular offense, the lying witness testifies in two ways that would be considered criminal. He testifies against the interest of the accused, or he testifies to harm the accused. The change, criminal cases, also covers an instance where the lying witness testifies for the accused, and both instances is in the criminal case. Thank you, Mr. Chair.
So the emphasis is...
Good morning, Your Honors. A little observation on this provision, Your Honor, because I have been in litigation and I have in the prosecution service. I have not seen any. I've heard of any case filed against a witness or giving false testimony. Seldom that we seen. I read in the decisions promulgated by the court that the decision itself categorically states that the witness gave a false testimony. Most likely, the wordings of the decision, the court cannot give credence to the testimony of the witness. So may I ask our colleagues, although we propose this testimony to retain the provisions under the revised penal code, with a modification as to the nomenclature, instead of the defendant, we use the accused. How are we going? Can we set a parameters on how to deal for the purpose of filing a case, indictment of the supposed witness who gave the false testimony, and for the successful prosecution of this case? Because all we know, even the practicing lawyers, mga witness natin, di ba? Although, siyempre, hindi naman sasabihin dahil covered yan ng privileged communication. For example, going further, although mamaya pa yon, offering a false witness. Delikado yung mga, because I was also a police officer, mga investigador, they were on the ground, they were investigating a crime. Suddenly, a person crop up stating that he saw the incident. So, magkakaroon tayo ng problema dito. Baka sa susunod, pati prosecutor, demanda nila. Because, pero hindi naman pwede yun because we are just presenting the witness. So that's my point. If we can set some parameters in order, hindi maging parang provision lamang dito sa batas na wala namang, it does not serve the purpose of being included in the revised penal code.
Okay. Yes.
Just in addition, before Attorney Bilang would be given the floor, Your Honor, this provision is a suspended provision, meaning to say that you cannot file criminal charges against a person giving false testimony until such time that the case pending is become final and executory. Our problem here, Your Honor, is that by the time that the case becomes final and executory, we have no more witnesses to present for purposes of filing a case under Article 186 of the draft, Your Honor. That's the reason why, if we can conceptualize something that would allow us to, even during the proceeding of the main case, if there is already a prima facie case of prima facie evidence of false testimony, the accused should be given a remedy, or even the private complainant should be given a remedy, Your Honor. Thank you.
Yes, please.
Yes, please.
Do I get it right
Justice Antoine.
Yeah, do I get it right under paragraph 3? The penalty of present correctional, if the accused shall have been sentenced to any other penalty or shall have been acquitted. And then there's another paragraph. In case the false testimony in a criminal case is favorable to the accused, the person giving it shall suffer the penalty of arresto mayor. Parang conflicting. Yeah.
No,
This is a conflicting
Yes,
provision.
Your suggestion for
My
justice.
suggestion is to erase the last paragraph.
Why?
In case the false testimony in a criminal case. It's the same with paragraph 3. Erase lang.
Mr. Chair.
Mr.
Mr.
Yang.
Chair. Well, with all due respect, but the provisions in the first paragraph covering the penalties is a situation wherein the lying witness, the testimony of the lying witness has been material in the conviction of an innocent person. So it results to a conviction. The last paragraph, Mr. Chair, covers a situation wherein even if the witness has lied under oath and it is criminal, but there is the presiding judge somehow managed to see through the lies and properly acquitted the accused. So there is no penalty imposed on the accused. But the accused in this particular case is indicted and prosecuted because the lie is an offense against the administration of justice, only that it did not result in the conviction of the innocent victim. So to us, there is a world of difference, Mr. Chair, because the first witness testified falsely and it resulted to the conviction of an innocent person.
Paragraph 3
Thank you,
also
Mr. Chair.
provides that there is an acquittal. Yeah, the last portion of the
Yes.
paragraph is acquitted.
Yes, Justice.
Yeah.
there is an acquittal, but
Yeah, in the same false testimony.
the testimony was against the accused. In the last paragraph, it is favorable to the accused.
That's the distinction.
Yeah,
Justice.
paragraph 3 is favorable and is acquittal and conviction. Then the last paragraph is favorable to the accused. It's one and the same.
Prosecutor Horda, okay, you are recognized. Can you, right. So that we try to resolve this one.
We discovered that in paragraph 3, which reads, the penalty of prison correctional if the accused shall have been sentenced to any other penalty or shall have been acquitted. So we saw that in paragraph 3, there seems to be, it's not commensurate to the offense as charged, because, for example, if the offense charged is has a penalty of arresto minor, meaning to say that you will be penalized with a prison correctional, which is higher, as compared to that of the RPC. There seems to be no penalty for those arresto minor. But here in this particular paragraph 3, there is already a penalty. So we suggest that we just have to more or less adopt the RPC insofar as the penalty is concerned. Imagine if you are committing a crime which is punishable with arresto minor, and then you will be penalized because of that testimony. You will be penalized prison correctional, which is higher than that which is charged. So we saw a little disconnect here.
Bilang.
Building off of that, a bigger suggestion. I noticed that our revised penal code focuses primarily on the damage to the accused, which is not a bad perspective. So what it provides is, depending on which crime you're convicted for or convicted with, the penalty for the lying witness will be commensurate to that. But the idea of perjury is it's an affront to the administration of justice. You know that there's an oath, there's an affirmation, you're supposed to tell the truth in front of the court, but you're not doing it. So it's primarily an affront to our justice system, and that's how it's been approached also by many other countries. So in many other countries, they impose a straight penalty, regardless of what the outcome was. If you lied in court, then there's a specific penalty for use. For example, in Spain now, their current criminal code is your penalty for false testimony, regardless of the outcome, is 3 to 5 years, period. Regardless if the person was convicted for reclusion perpetua, reclusion temporal, or whatnot. So I'm offering that as an alternative to our framework right now, because right now we're focusing so much on what is the effect on the victim, what is the crime for which the accused was convicted for, when in reality the crime committed here is against the administration of justice. Thank you.
Prosecutor Nahara.
Yes, thank you, Mr. Chair. The observation of Justice Ampuan is premised on the fact that the Article 186 provides for two situations. Because in the present wordings of the revised penal code, the false testimony in criminal case is subdivided into two articles, and that is 180 and 181. Now, 180 pertains to false testimony against a defendant, meaning the one who is testifying is a witness for the prosecution. Now, 181 pertains to a situation where a false affiant testifies in favor of the defense of the accused. Now, in the wordings, in the proposed wordings or draft of the DOJ, we just incorporated these two provisions, 180 and 181, into one, and that is 186. That's why the good justice seems to be confused of this simply because naging isa yung dalawa. So this, I think the good justice has a good observation, whether or not we will retain the two articles or we'll just adopt one article for this. And also the observation of Attorney Bilang is well taken, since we have to resolve this whether we will maintain the two articles or just we have one consolidated article. My personal view is that it seems na parang ambiguous yung Article 186 because nagbabanggaan yung number 3 and the next paragraph. Medyo malabo, subject to different interpretation yan. So I would toss to the body whether we will adopt the present wordings or we just adopt the DOJ version, Mr. Chair.
Yeah, okay.
May I just raise a situation wherein initially a witness, for instance, gave probably his personal knowledge about the commission of a crime. And eventually, after the termination, say for instance, of the presentation of evidence in chief for the prosecution, they recanted. How would we treat that now? Initially, it is favorable to the private complainant or to the people, and then later on, it becomes now favorable to the accused. That is the use of this provision.
Which is happening in many cases.
That is now the almost a practice in every court proceedings, that there are a lot of recantations that would really damage the administration of justice, Your Honor. That is one thing that I think we also need to address. One thing is one suggestion is that to really increase the penalty in order to deter people from recanting their testimonies during the course of the proceedings. Thank you.
Chair, pagka-recanting ba, is that perjury ba yun?
Yes.
Yeah.
So, yung sinabi mo ngayon, binawi or pag-amin ba yun na hindi totoo yung sinabi mo? Okay.
Well, there is, Your Honor, there is already a 360-degree turnaround. So you are already refuting what you have mentioned in the early proceedings. So that would really benefit the accused. Na supposedly you are a witness for the prosecution.
So sabi nyo, parang common practice na yan, nagre-recant.
Marami
Okay.
sa husgado.
Napo-prosecute ba sila for perjury?
This is the problem now because you need the finality of the first case before you can prosecute them under this provision.
Pero kung as a result of the recantation na-dismiss yung kaso, di ba pwede ka na mag-prosecute?
If it is already dismissed or in criminal cases, that's already double jeopardy, sir.
No, prosecute for perjury.
Yes, but you need finality. That is the condition, President, before you can invoke Article
Okay, so
186.
kunyari, nag-perjury, tas na-dismiss, but then you prosecute for perjury and prove that there was perjury, hindi mo na pwedeng i-prosecute hindi mo na pwedeng baliktarin yung dismissal.
Oh, well, there are remedies if you really believe you can avail of the benefit of Rule 65 of the rules of court, grave abuse of discretion, but it's really very difficult to do it, Your Honor. Very tedious.
Okay.
Okay. Ocampo.
agree with the observation of my friend Prosecutor Camora, Your Honors. Huwag na po lang tayo lumayo dun sa makukonvict, madidismiss eh. Yung sa, at the early stage of the trial, nag-testify na yung complainant, witness, complaining. Of course, during the early stage, tinetestify niya pertaining to the case he filed against the accused. But in the middle, na-reset ang hearing, na-reset for continuance. Nagkausap sila. After that, nagkasundo. So, ang susunod na step, in order to secure the dismissal, to execute an affidavit of the desistance. Ang sinasabi natin sa affidavit of desistance, the filing of this case was a result of a misunderstanding and misapprehension of facts, which is contradictory to the testimony. At yung witness natin na yun, yung most likely sa mga trial lawyers dito, pinipresent natin yun sa witness stand to identify the affidavit. Doon pa lang, kitang-kita naman na yung variance ng dalawa. First, nag-testify siya, talagang sinabi niya, ginawa ng witness to. Later on, nagkaroon ng desistance, misapprehension, and misunderstanding and misapprehension of facts.
Chair, that was my clarification I wanted. Pagka sinabing misapprehension or misunderstanding of what I said earlier was now, having thought about it, was a misapprehension or misunderstanding of facts. Is that legally considered perjury? Perjury ba yun?
For me, sir, with all due respect, I have to draw the distinction between false testimony and perjury. Because when the false testimony was given in a judicial proceedings, we treat as a violation of Article 180 or 181, and now on the proposed code 186. And if perjury, it presupposes that the statement was given outside of the judicial proceedings, sir.
Now, what we are taking up is false testimony given
Court.
Must clearly state false testimony in criminal cases. Are we agreeable to that? And then we go to that. Shall we agree?
Yes.
Oh, everybody agreed. All right. Next is all right. We now go to this point.
Mr. Chair.
Yes, sir.
Justice.
Yeah, the problem in our judicial system is that we always violated the basic principle that criminal laws cannot be compromised. And if you execute an affidavit of recantation, it is compromising our criminal laws.
Yes, sir.
Mr. Chair.
Oh, okay. Prosecutor Ocampo and then Nohara.
Kaya nga, sir, I find the issues raised by the Honorable Congressman Tino very novel. This is only the time that we can encounter the situation. Yung kung pwede later on, napatunayan natin na guilty siya for giving false testimony. Paano naman yung victims na whose right was violated, was denied, di ba? Kaya yun ang dapat tignan natin yun, because that is the direct consequence of that crime committed by false testimony. Kaya kung professor si Congressman Tino, mahirap sagutin sa exam.
Pero hindi, yung tanong ko pa rin nga is, okay, hindi perjury, false testimony ba pagka sinabi ko, well, yung sinabi ko earlier is due to a misapprehension pala. So, meron akong desistance. Okay? Is that considered false testimony? Parang hindi. Kasi mukhang it's taking advantage of a loophole. No? Na, well, nagkamali lang ako, sorry. Which is different from false testimony. Conscious ka na kasinungalingan yung sinasabi mo. Di ba ganon? Okay. So iba yung, I mean, the prosecutors here want to address that loophole. Di ba? Nung desistance. Alam natin yan ang kalakaran sa arigluhan. Di ba? Okay, pero baka hindi ito yung proper place para ma-address yon. Yan ako, nire-raise ko lang po. Anyway.
Your Honor.
Prosecutor Nohara and then
Thank you,
Rikamura.
Mr. Chair. I think the issue that should be resolved is how are we going to treat this affidavit of desistance and affidavit of recantation. But if we are going to look at the jurisprudence, the Supreme Court has no hard and fast rule, so to speak, with respect how to treat this affidavit of desistance. The rule, general acceptable, is that affidavits of desistance or affidavits of recantations are looked upon with disfavor. At tama yung sabi ni Justice Ampuan na hindi po pwedeng i-compromise ang criminal case despite the agreement or compromise ng private complainant and the accused. Now, I am also at a loss. I've been reading criminal cases. I have one case decided by Justice Leonen. This is a vowsy case. Now, the accused was sentenced by the trial court, and the accused went to the Court of Appeals. While pending with the Court of Appeals, the victim, the woman, the victim, executed an affidavit of recantation. Now, the Court of Appeals set aside and affirmed the ruling of the RTC on VAWC, violence against women. When this case reached the Supreme Court, I'm specifically referring to XXX 264870, April 16, 2025. This is the ponencia of the Senior Associate Justice Leonen. Justice Leonen entertained the affidavit of recantation. Sabi niya, the affidavit of recantation negates the element of mental anguish on the part of the woman victim. Now, justice na to si Justice Leonen, pero in-entertain niya. He gave due course to the affidavit of recantation na inisnab na ng Court of Appeals. So, the prevailing rule, per this jurisprudence, pwede pala ang affidavit of recantation nakarating na sa Supreme Court, and yet, na-recognize pa ng kataas-taasang hukuman. So, can we override, can we supersede the Supreme Court on this by having an express provision in this proposed draft that affidavit of recantation or affidavit of desistance cannot be recognized? Because I think that is the Congress has the plenary power to determine what the law is, despite the jurisprudence of the Supreme Court. Thank you, Mr. Chair.
Okay.
I'm sure that all of us are aware there is one case in the Supreme Court wherein the witness recanted, and then the Supreme Court acquitted the accused. Yeah, I know. I know you're familiar of that case. Ito, tatlo yung namatay.
Well, we handled a case convicted by the RTC. It went to the Court of Appeals while pending in the Supreme Court. A settlement was reached. The Supreme Court affirmed the conviction.
Yeah, that was.
Mr. Chair. Mr. Chair.
Masakir yun eh. Masakir. Yung
Two things. First, may I clarify with Prosecutor Rikamora? Saan po yung kailangan may judgment na para mag-proceed into perjury? Is that
In criminal cases.
Sa ano po?
In criminal cases, no, but not during the pendency of the criminal proceedings, nobody would. You cannot determine whether the false testimony. Kaya nga.
Yeah, currently po, is that a Supreme Court decision or kalakaran lang sa baba?
Saan?
Sa yung hindi magkakaroon ng perjury case pag walang finality yung decision.
False testimony.
False testimony.
Yes, false testimony.
Yes. So, saan po yun? Supreme Court
Yes,
decision po?
Tama. Jurisprudence. And insofar as the draft, Your Honor, It's there. It's there. That in cases of false testimony in criminal case or cases is
Yes.
tama is favorable to the accused, the persons giving it shall suffer the penalty. The last paragraph, in all prosecutions under this article, prior judgment in criminal case in which the false testimony was given shall be a condition
Yes,
precedent.
yun nga, but that's why I'm asking kasi we can just delete that and retain yung previous wording of the revised penal code which doesn't have that paragraph. Para at least, even if the case is still ongoing, you can proceed to the perjury if there is really falsity. Right?
Yes, Your Honor. May I respond, Your Honor? The only problem here,
Response, can we recognize our Honorable Congresswoman Ana Victoria Veloso Tuason?
long time no see, Your Honor.
Good morning po, Congresswoman.
All right.
But we are seeing you
proceed.
on television, Your Honor.
You now proceed.
Yes, Your Honor. The only problem is that you don't have anything to anchor false testimony if the court will not declare that the testimony so given during the proceedings is a false one.
See, I'll think about it later. Another point lang po, and then I'll proceed from the discussions with Justice Ampuan and Prosecutor Nahara. I think this is not the place to altogether forbid affidavits of recantation, affidavits of desistance, because they have value. Think of a case where the witness has already given their testimony in court, and because of their conscience, they realize they need to tell the truth. And their second testimony is the truth. The first one is the falsity. If we say that once you've testified, you cannot recant that anymore, you cannot change your testimony, what we're doing is we're preventing the correction of the falsity if you don't allow people to recant their testimony. At the end of the day, what we want, court proceedings are for you want to discover the truth in a judicial proceeding. And why will we prevent it just because magulo or gusto natin touch move ka na pag nag-testify ka na, yun na yung testimony mo, no? So I think personally, the case-to-case basis by which the court approaches affidavits of desistance, titignan kung baka mamaya out-of-court settlement yan, or baka mamaya nabayaran, or any other reason. And for that, the merit is determined by the court whether or not to give credence to the affidavit of desistance is much better compared to an outright ban on affidavits of desistance or recantation.
Mr. Chair.
May I respond?
Mr. Chair.
Yeah, before you respond, and let us also distinguish was given the false testimony. Is he the private complainant or a witness? Because there's a big difference here. Now, if he is the complainant, now, again, in some of the culture of our indigenous people, settlement of any kind of cases is by all means a priority. The rationale is, if the case is settled, the possibility of revenge will be prevented. But if no settlement, then just wait for the time that you will also do the justice by yourself. That's why, as I said, let us distinguish false testimony, recantation of the private complainant or the witness.
Yes.
Chair.
Yeah.
Yeah.
Okay.
Chair, I think dito sa 180, yung pinag-uusapan natin, it's a false testimony of a witness. Hindi yung defendant mismo. So yung actually, affidavit of desistance does not apply here. Kasi the only one who can desist is the complainant himself or herself. Diba? So ang pinag-uusapan natin dito, recantation. Now, recantation, by definition, is recanting. In other words, you're admitting that your original testimony was false. Tama ba? Okay. So, ibig sabihin nun, ibig sabihin nun, meron ka ng liability doon. Di ba ganun ang effect nun? If someone files, I recant, sabi ko, siya yung gumawa, pero hindi pala siya. Itong totoo. Okay, so, may liability na yung under. And ano ba ang practice? If that happens, are they actually charged? Hindi. Bakit ganon? Parang yung kayo may problema. Why don't you charge? Or is it pwede bang because of certain consideration, like baka mamaya coerced pala to? Pagka ganon, how do you, the original testimony was due to coercion. Tinreten siya. Tapos nag-decease later. So, ano nangyayari doon?
Okay. Restore. And
Thank you.
The lady.
Thank you, Mr. Chair. But can I go back to the matter at hand, Mr. Chair? we are dealing with the false witness here, the false testimony. I think, Mr. Chair, earlier you asked if there is any comment or objection to the use of, to the change of the word against a defendant to our proposal in criminal cases. I think there was no objection. The only problem is that, as appropriately pointed out by Justice Ampuan, is that there seems to be disproportionality in the application of the penalties. In that regard, Mr. Chair, I think, this is my personal view, Mr. Chair, I think the most sound approach is the view of Attorney Bilang, because this is essentially an offense against the administration of justice. And if the point of Attorney Bilang is that it does not really matter if the false testimony was against or in favor of the accused, then we ought to have a uniform penalty on the matter. I think that is the most practical and the best approach to have a common ground insofar as the penalty is concerned, because once we have that agreement or consensus, then I think we can move on to affidavits of recantation. That will be dealt with in the crime of perjury, Mr. Chair. Thank you, Mr. Chair.
Okay.
Chair.
Well, personally, I agree that really doesn't matter what is the penalty that will be imposed as a result of the false testimony. The moment a false testimony is given, that's violation of the administration of justice, and it will be good if we can come out with a uniform penalty on that matter.
Chair. Yes. Well, okay, if we grant that, then the next question will be, what is the penalty that will be imposed?
Yes.
Kung hindi na nagmamatter whether this is the crime is murder or snatching, cellphone snatching, ano yung penalty na impose mo? Okay? So, because for example, someone is charged with murder, tapos, pwede, you can think of a scenario, babayaran ko na lang itong taong to, sabi mo, magkasama tayo okay. And then pag natuklasan pala na nag false testimony siya, the penalty is just whatever. Arresto minor. So parang may gano'n naman. Di ba? Paano yun?
Very good question. Yes,
I think we're just after paragraph 3. So there is a suggestion that the penalty shall just be uniform. It must be prison correctional.
Well, I'm just raising, Chair, yung concern nga na then doesn't that kind of lower
Prison correctional na lang lahat.
parang yung deterrence dun sa babayaran ko lang to para sabihin na magkasama kami nun, hindi siya yon. Parang ganon.
That's Mr. Chair. That would be Mr. Chair. that would be another offense because that is presenting a false witness. There is in our succeeding proposals that will be taken care of because if you would say that I'm going to pay this witness, then you will be a principal by inducement. You will be a mastermind. That is subornation of a false testimony. And there is a particular penalty in our proposal, Mr. Chair.
Now, okay. So can we now resolve what's the proper penalty? Shall we agree that we will impose uniform penalty for the third paragraph of this, regardless of the penalty that will be imposed as a result of the false testimony? Agreed? Yes.
Yes, on my part, following the discussions and the discourse of Congressman Dumagang, Congressman Tino, and Attorney Bilang, as well as my colleagues from the DOJ, first, we now agreed that giving of false testimony is a condemnable offense, regardless of its effect, whether it favors the accused or against the accused, because it's a affront to our legal system. And it ruins the life of the innocent one and gave injustice to the victims because of the false testimony. So, siguro, we have to decide what range of penalty are we going to give. Is it prison mayor or prison correctional? If the penalty will be lower, it will open the floodgates sa mga ating mga binabaya. May mga witnesses na talagang who are for sale. Alam na ho na, lalo sa mga polis, talagang malalaman natin yan na nagpapabayad. Oh. So, siguro, on the part of the DOJ, prison mayor tayo. Prison yan, correction na lang. For me, because my colleagues might be attacked later on, prison correctional instead of prison mayor.
Can we hear an answer to that before I will turn over the chair to our honorable chairman?
Mr. Chair, I think the earlier observation of Justice Ampuan was not addressed. Yung seeming contradiction between the third paragraph and the next paragraph, hindi ata na-address eh. So, I would respectfully move or request that we just retain Article 118 and 181 to avoid any confusion. This is not so a controversial provision of the law, since the original or the present wordings seems to be clearer than the present and than the proposed draft, Mr. Chair. So I would suggest we just adapt this. I think the only issue here is to have a uniform application, whether it is civil or criminal case. Kasi sa civil case, the next article, it does not require the termination of the case. So immediately you can file a complaint for false testimony in civil case. But that is not the rule in criminal case. You have to wait for the resolution of the criminal case, because that will be the basis for the penalty of the false affiant. I think that is the rule to be that is the more controversial issue that must be resolved by this honorable body.
Okay. So there's another suggestion now that we just retain Articles 181 and 182. Okay?
Pero Chair, I think yung proposal to just provide a standard or uniform penalty or range, baka may merit. Kasi nga, yung sinabi, dahil nakabatay sa penalty ng crime, kailangan hintayin mo pa yung conviction. Di ba? So matagal. Bago ka kung natuklasan na false pala to pwede dapat sampahan na ng kaso. Ganon. So, pag may standard penalty, di mo na kailangan hintayin yung final judgment. So, ano tingin nyo? Parang may wisdom yon.
Attorney Bilang.
Yeah, just to support that, kasi andun na tayo Nasa standard penalties na po tayo kanina, and I support that even the suggestion of Justice Ampuan to impose uniformly prison correctional, just to address the pending point of Congressman Tino earlier, I think the weight of the penalty we impose will not really matter in terms of, even if it's a murder case, even if the pending penalty to be imposed upon you will be reclusion perpetua, if you really want to lie, you will lie. It doesn't matter if it's prison correctional, if it's reclusion perpetua, diba? So it will not really dilute, so to speak, the crime. And I'm all for, as I've mentioned earlier, the application of just a straight penalty for all kinds of false testimony in criminal cases.
All right. May I now turn over the chair to our honorable chairperson.
Pero,
And I ask for
Chair,
suspension
in
to-
a quick response to that lang. Okay naman ako doon, but you may have a situation where the false testimony will have a heavier penalty than the original crime. Diba? Yung parang yung nire-raise kanina na ito, ano lang to ano ba yung mas mababa sa prison curriculum? Arresto menor o mayor, whatever. So basta ganon, basta okay lang sa atin yon.
As I said,
Walang problema na mas mataas.
Right, true. Good morning, everyone. Let's all settle down. My apologies for the late attendance, but I appreciate the Congressman Dumogan for presiding in my absence. So feel free to have lunch as we discuss. Nandito pa rin ho tayo sa Article 186. Tama po ba? In the last committee meeting, this is where we left off. And now we're picking up. We haven't moved. So anyway, I caught the tail end of the discussion. So it's really not clear to me exactly what was discussed. But do you mind if we just, we're gonna discuss this as if this was not previously discussed, but in a more cursory manner, but just to, I can catch up with the discussion. So Article 186, itong false testimony in criminal cases. What I understand from the discussion when I walked in was this false testimony. It has to be by final judgment, correct? Because if you look at the penalties are graduated depending on the outcome of the case. So merong sentence to death, merong reclusion perpetua, afflictive penalty, acquittal. So it's that, okay? Do I take it that? And then Article 186 was read in tandem with a false testimony in civil cases. Tama, parang naging ganon. Because in false testimony in civil cases, do I read it? It doesn't have to be by final judgment in civil cases? Ganon ho ba? Ah, okay. Okay. There has to be a prior judgment for it to apply, right? The question then is, the prior judgment, does it have to be final? It has to be final. Okay. So, are those two articles aligned? In that, it both require final judgment, correct? So what was the issue that I'm missing? Prosecutor Ocampo.
Good morning, sir. To Congresswoman Tuasan, good morning po. During the break, we have a comprehensive and in-depth discussion, as well as a heated exchange of ideas. We came up with a position as far as the penalty is concerned. The DOJ came up with a position, and prudent dictates that I have to yield the microphone to Chief Abadia to fully discuss the position of the DOJ.
So, Prosecutor Abadia.
Good morning, Mr. Chair. And good morning, everyone. So, considering all the discussions this morning, we have come up with a unified stand that Article 186 shall still be a consolidation of Articles 180 and 181. But in order to prevent confusion, whether or not the false testimony is favorable or unfavorable to the accused, we propose that this be worded in this manner. Article 186, false testimony in criminal cases. Any person who shall give false testimony in any criminal case. So with this, we propose that the against the accused phrase will be removed so that whether or not is for the accused or against the accused, then the perpetrator will be penalized. And then, considering the proposal of Attorney Bilang to have a uniform penalty, considering that the gravamen of the offense is really the giving of the false testimony, we propose a penalty of prison correctional and a fine of not more than 200,000 pesos as stated in the draft. And then, so effectively, Your Honor, the paragraphs 1, 2, 3 will be deleted because we already have a uniform penalty. But then, in order not to open the floodgates for baseless cases on false testimony, we still propose that the last article be included, last paragraph, which says, in all prosecutions under this article, prior judgment in the criminal case in which the false testimony was given shall be a condition precedent. And so the third paragraph, Your Honor, the second paragraph, which says, in case the false testimony in a criminal case is favorable to the accused, the person giving it shall suffer the penalty of arresto mayor and a fine of not more than 100,000 pesos will be deleted also, Your Honor. And Your Honor, please, may we include the word final in the last paragraph to say, in all prosecutions under this article, prior final judgment in the criminal case in which the false testimony was given shall be a condition precedent. That would be all, Mr. Chair.
So you want to paraphrase, which is an indication of whether I understood it or not. To paraphrase it, you want to basically just penalize the false testimony regardless of outcome.
Yes, Mr. Chair. That is
Okay, and that it has to be clear that it has to be by final judgment in the last paragraph.
Yes, Mr. Chair.
Anything else that I missed in my paraphrase?
No more, Mr.
Okay.
Chair. Thank
No,
you.
here's a question. Just, I mean, we all recognize the rationale for why it's outcome based, because I mean, to argue for, the status quo, which is outcome based. I do understand that false testimony is false testimony, but I think the lens is from the point of view of the accused, which is that if false testimony is given, sabi nga nila, there's a what do you call this, the view that mas mabuti na mapakawalan yung may sala kesa makulong ang inosente. Viewed from that perspective, then you realize why this is outcome-based. And the outcome, of course, it varies in severity, from imprisonment, depending on the duration. And so it's graduated because for that reason. Are we willing to sort of look past that? Because by collapsing, if you don't make it outcome-based, then, then what about the prejudice, to the accused? Don't you feel that, to some extent, that we should look at the penalty imposed on him or her? Attorney Bilang.
Thank you, Mr. Chair. I was the one to initially suggest that earlier during the early part of the discussions to offer the view. It's not really bad to look at the outcome of the case. Right? We can choose to do that, of course. But then again, criminal law always looks at the offender. What's the mens rea of the offender? And the offender here disregards the oath or affirmation that he or she took as a witness. So that's really the gravamen of the offense. The offense is made against the state in that it undermines the administration of justice. Yes, there is harm. There's concrete harm to the accused, but when I proposed this, I was saying that let's take the position that the offense is made against the state, not really against the individual. To take also an example from other jurisdictions, I mentioned earlier that in other jurisdictions it's a straight penalty. In the US, yes. In Spain also, right now their current criminal code punishes false testimony regardless of outcome with 3 to 5 years of imprisonment. Because again, the gravamen is the offender. So up to you, of course, if you want to revert back to the graduated scale, but that's the rationale behind the proposal.
If is there a remedy that for to address false testimony without waiting for the outcome? Would perjury be a remedy or an avenue that a prosecution may pursue to hold somebody accountable for lying under oath?
Mr. Chair.
Prosecutor Cristorio.
Thank you, Mr. Chair. Not in the provisions under the revised penal code in our proposal, Mr. Chair, because as provided here, it is a requirement that there should be prior final judgment or a final conviction. But insofar as the idea of having a uniform penalty, Mr. Chair, in Republic Act 11594, the state has increased the penalty for perjury. And in the crime of perjury, Mr. Chair, it does not result necessarily in harm to a particular accused, because that is perjury outside of a court proceeding. But the penalty is already prisión mayor. So if we can address this issue about the appropriate penalty, we can make the penalty higher than prisión correccional, so that it will somehow be consistent with the crime of perjury. Instead of prisión correccional, we can impose the penalty of prisión mayor to address the harm that is done to the accused, the innocent person. That is all, Mr. Chair.
So in in a crime of perjury under the statute, it doesn't apply to...
No, Mr. Chair, because what we're dealing here in Article 186 is a lying witness, one who testifies in court, either a criminal or a civil case. In perjury, that is a lie under oath, but done outside of a court proceeding, which may include a Senate inquiry, congressional inquiry, or an administrative proceeding. No harm really to any particular accused. So if we have to address the harm to the accused, then we might as well increase the penalty to make it uniform with Republic Act 11594, Mr. Chair, which is prisión mayor. Thank you, Mr. Chair.
Any comments, Attorney Bilang?
I'm going to address po your question on is there a remedy to an accused despite the pendency of the case. We were discussing earlier during the break that was a concern because it takes a long time for cases to finish, right? So if you have to wait for a final judgment, there's a chance that witnesses are gone, people don't want to prosecute anymore. So we toyed with the idea of removing the proposed last paragraph of Article 186, which provides for the final judgment. Personally, I'm all for the idea that there should be no need for a final judgment. We can just insert demonstrably in the first part, which is any person who shall give a demonstrably false testimony. One example I can give, I was giving it to Prosecutor Cristorio earlier, is, for example, if you're a witness in a criminal case, you're supporting the alibi of the accused, you said, yeah, we were in Cebu during the time that the crime was happening. But there is proof, for example, that there's a CCTV footage that you are in Manila where the crime happened. That is demonstrably false. It's demonstrating to everyone that that the testimony that you say that you're in Cebu is false. So if it's demonstrably false, that should, in theory, go separately, be prosecuted separately, even if the criminal case is still pending. We can insert that. That addresses the problem. Your question on remedy is: does the accused have a remedy when someone testifies for or against them falsely? Another positive thing about adding demonstrably false is right now it just says false. What is false? Is a half-truth, falsity, is an honest mistake, false. You are an eyewitness. You said that the attacker was wearing yellow clothes. You sincerely believe that what you saw was yellow clothes. But then CCTV footage demonstrates that it's a different thing. No? Hindi pala siya naka-yellow, wala pala siyang tattoo, etc., etc. And we've seen that happen a lot of times because eyewitness testimony is quite unreliable. Our memories don't work like video recorders, right? So putting safeguards on what false is has some merit because right now it just says false and we don't define what false is. Thank you.
Prosecutor Horda.
Just a reaction to Attorney Bilang's manifestation earlier. Imagine if there is a scenario here that a case is pending and there was already a testimony that was given and allegedly it's false, and then a case is filed against that person who gave that false testimony prior to judgment. So you have a scenario here that prior to judgment, there's already a case against that person who falsely testified. So it would not constitute sub judice on the part of that of the original case being heard. And also, if it is a civil case, would it be like akin to prejudicial question? So that's
the other question also that I want to raise before I give the floor to Attorney Bilang is that at that particular point when the false testimony, demonstrably false testimony is given in court in a criminal case, does the judge have jurisdiction to actually at that particular point address that? Because parang ano yan in flagrante, caught in the act. So it happened before the judge. At least in law movies in the United States, we've seen this when there is a false testimony given in court, the judge immediately addresses it. No, so Attorney Bilang.
Yeah, from Prosecutor Horda's manifestation, I agree. The prosecutors are bringing up a lot of dangers with regard to if we allow perjury prosecutions to prosper even during the pendency of the case. So, for example, they also brought up the possibility of it being a harassment suit against the witnesses. So I also recognize that that's also equally valid. So really, it's a policy question now on the body. Do we want that to? Do we want to for perjury prosecutions to proceed, given the practical implications of it, or do we want to give a remedy, as you say, to the person on the accused person who's now being prejudiced by the false testimony of the witness? Thank you.
Prosecutor Horda.
Actually, sir, our suggestion is actually based on the jurisprudence of People versus Maneja, where the court said that it is a prerequisite. Final conviction is final judgment is a prerequisite before the case on false testimony can be filed. It is in the People versus Maneja. It's an old case.
Yeah. So we're trying to fill a vacuum. Am I right? And the vacuum is that if false testimony is given in a criminal case, there is no remedy, or it is not criminal. You're trying to fill that because earlier, Prosecutor Custodio mentioned that perjury only applies to written submissions under oath outside court. So there's a gap. Tama? Are we on the same page that there is a gap? Okay, and we're trying to fill that gap here, right? So my thought then is, why are we First, why are we thinking of doing away? Why are we thinking of making it not outcome based? We can do that. We can address it, but don't you feel that? Don't you think that? To address the concern about the innocent being put behind bars or being penalized, or to give premium, to add premium to that we should at least retain the outcome base and then just put in a provision for false testimony given that it's not outcome based. Do you follow? Kasi in other words, kasi nasabi ko ganito, sa RPC ngayon outcome based. And I think the reason for that is, as I mentioned, because can you imagine, it's one thing to be incarcerated, it's completely another thing to, of course, it depends on the duration. So it's the lens is like, I think it's not because the question of like, is it a crime against the state or a crime against the victim is really, that's not really the distinction. But rather, I think what the state is doing here is that it's using the prejudice to the victim as a means of graduating the penalties. Yun ang ginagawa niya. But it's still the state taking the, doing this, pushing this. So, sinasabi ko, hindi ba pwede? But again, it's I don't want to overthrow the entire, the status quo, unless there's compelling reason, because there is, as pointed out and recognized earlier, that there's something about the prejudice to the victim, diba? So, what if we retain, make it outcome based, right, and then just fill in the gap? Maybe a lesser penalty.
Mr. Chair.
Prosecutor Cristoria.
Just for the record, Mr. Chair, to that point, the proposal actually, our proposal, Mr. Chair, the proposal of DOJ is actually outcome-based because we are treating lightly insofar as the penalty for the accused who testifies falsely in favor of the accused. We are proposing a lighter penalty. It's actually arresto mayor, Mr. Chair. So this would somehow show that we are proposing an outcome-based penalty.
Yung parang, so your proposal is aligned with my thoughts.
Outcome-based.
Pero yung with respect to the proposal of Attorney Bilang about the inclusion of demonstrably, I'm all for that. Just because truth or falsity is sometimes subjective, so it has to be objectively false, and therefore demonstrably false. Which, by the way, is the language used in legislative measures that pass third reading. In particular, the digital media anti-false information, that it has to be demonstrably false. Kasi otherwise, baka opinion na yan, di ba? Do you have any objection to the insertion of demonstrably false? No objection. So I'm just trying to pin down, and narrow down the issues. And so it seems to me, and I'm stalling also so I can catch up, because I was out. Okay, that's what I'm not saying. Okay, and that's what the audience watching is not hearing. Okay, is the issue is really whether to retain parts of the aspects of the current provision on the revised penal code, which is outcome based, and then filling in the gap. And the gap that the RPC presents is, what if it's in favor of the accused? Tama po ba? Okay, I've stalled enough. Attorney Bilang.
Yes, if the policy direction that we're going is a graduated scale, and no strong objections to that, but we following Prosecutor Custoria, we should align properly the ones where the outcome is an acquittal and the testimony is given in favor of the defendant. The false testimony is given in favor of the defendant. Because at the end of the day, you still lied to the court. So, yeah, as I was saying, you're still compromising the administration of justice. And that's prejudicial not just to the state, but also to the private complainant if there is. So, perhaps a two-tiered penalty where if it's a capital offense, reclusion perpetua, life imprisonment, this one, and then for all other things, we can impose a uniform penalty.
Just to make sure I understand. Justice Ampuan.
Actually, sir, that is already provided in the proposed revised. 1, 2, 3. And I just questioned last time because there is apparent inconsistency with the last paragraph.
Last paragraph.
And we agreed that it must be, instead of arresto mayor, we will just adopt one penalty, and that is prison correctional for all cases.
For all cases?
Aside from penalty of reclusion temporal and penalty of reclusion perpetual.
So, Justice Ampuan, you're saying that keep 1 and 2? Tama po ba? Keep 1 and 2.
I agree with 1 and 2.
But number 3, you have to align the penalty with, since it's an acquittal, and then how is that different from giving testimony, false testimony in favor of the accused, which on the proposal merely imposes arresto mayor, so that should be prison correctional as well.
Prison correctional also. That was
Isn't that what you said also, Attorney Bilang? Attorney Bilang.
So the third paragraph would read, the penalty of prison correctional if the accused shall have been sentenced to any other penalty or shall have been acquitted or if the false testimony was favorable to the accused.
And also, I think in the interest of clarity and specificity, it's probably better to include that, para we cover all grounds. That's it. Anong palagay ninyo? Any thoughts on that, Prosecutor Abadia?
Thank you, Mr. Chair. If the policy direction is towards the graduated penalty, Mr. Chair, if I may suggest, maybe we can just adopt the original wordings in the revised penal code, which provides for paragraphs 3 and 4. The paragraph 3 says the penalty of prison correctional if the defendant shall have been sentenced to any other afflictive penalty. And paragraph number 4, the penalty of arresto mayor if the defendant shall have been sentenced to a correctional penalty or a fine or shall have been acquitted, Mr. Chair.
What about the Prosecutor, the favorable testimony to the accused, which is not addressed in the number 3 and 4 of the RPC?
In that case, Mr. Chair, we can adopt the one in the draft, which says in case the false testimony in a criminal case is favorable to the accused, the person giving it shall suffer the penalty of arresto mayor and a fine of not more than 100,000 pesos, Mr. Chair.
Yeah, I think, but the point of Attorney Bilang and I believe Prosecutor Cristoria, and also Justice Ampuan, is that there's really no difference between an acquittal and a testimony favorable to the accused, so that they should be penalized the same way. Yun ang, kasi ako, with the DOJ draft look, parang okay yung number 1, tama? Okay yung number 2. Okay, if you look at number 3 conflates actually number 3 and 4 of the RPC. Tama? Is it correct? It combines it conflates both. Kasi yung sa number 3 ng RPC is talking about an afflictive penalty. So if it's not reclusion perpetua and not temporal, what are the other penalty? Is it afflictive? Tama po ba? So here, because now, see, it's afflictive and correctional, right? Which is actually 3 and 4. So ginawa nung sa proposed DOJ draft number 3, pinaikli lang. Pinaikli lang. So other penalties, contemplating, afflictive, and correctional, correct? Okay. O sige, ano po yan?
It was raised also by Justice Ampuan a while ago, Mr. Chair, that there seems to be a disconnect because if you say any other penalty, it may be correctional penalty or light penalty. And if it's light penalty, Mr. Chair, it's going to be arresto mayor only, the penalty for the perpetrator, and then for the one who's giving the false testimony, it's already prison correctional. It's higher than the penalty for the accused, Mr. Chair.
Hindi ho ba, why did we need to change that? Why did we just keep 1 to 4? Yes. Why did we just keep 1 to 4 of the RPC? No need to rock the boat if it works.
Yes, that is our proposal, Mr. Chair.
And then just fill in the gap. Si Attorney Pangan before Attorney Bilang.
Mr. Chair, just a suggestion, why not retain separate provisions for false testimony against the accused and false testimony in favor of the accused? Because to be honest, I don't see any major issue in separating these two provisions. Thank you.
Ako naman po, I see the point. It's same. It gets you to the same destination in 2 different routes. But my only concern is strategically, they might, we'll be asked, why did you insert a new provision when you can just insert it in a related provision? Yun ang tingin ko, It's just a matter of style, Kasi sinasabi ni Attorney Pangan, I see we're all on the same page, di ba? We want graduation based on penalty graduation based on outcome, right? Which the RPC provides. Now there's a prosecutor over there points out, echoing the ideas of Justice Ampuan, that may disconnect, di ba? But then, if you look at yung RPC, tignan nyo, number 3. I'm not talking about 1 or 2, Sa 3, prison correctional pag afflictive. Arresto mayor pag correctional penalty or fine. Doesn't that cover all ground? So why are we changing it? Why are we changing it? That covers all the ground. Now, with respect to, what about false testimony in favor of the accused? Or that results in acquittal, then we will make the alignment there. So maybe we will broaden or expand the language of number 4 under the RPC to include shall have been acquitted or in favor of the accused. Naging aresto mayor yon. Diba, Attorney Pangan?
Mr. Chair, I believe that false testimony in favor of the accused does not always result to an acquittal. Sometimes it affects the penalty. For example, if a witness could testify in a certain aggravating or special aggravating circumstance because of his or her testimony, then it will affect the penalty imposed to the accused.
No, I'm not saying that it's tantamount to the same thing. I'm not saying that they amount to the same thing. What I'm saying is that earlier we were comparing sort of comparing the nature of the offense, right? One is somebody demonstrably falsely testifies, and the accused is acquitted. The other one demonstrably falsely testifies in favor of the accused, right? We're saying earlier it was raised. Parang same yan. In terms of severity, we're not saying they're the same, but in terms of how they should be treated by law, they're equally egregious. So therefore, the penalty should be the same. Yan ang sinasabi kanina, not that they are the same. So the question here is, do you agree that they're equally egregious, they're equally bad, so that the same penalty should be imposed for demonstrably false testimony resulting in acquittal and demonstrably false testimony in favor of the accused? Diba? Para i-default mo na aresto mayor na yan. Dalawang yan. Yun ang tanong eh. Not that we are not saying. Kaya nga ang suggestion ni Attorney Bilang earlier was dagdagan ng or resulting in acquittal or what do you call this? In favor of the accused. Ginanon lang niya. So there are two ways of committing it, sinasabi ni Attorney Bilang. Right? One way is, it results in acquittal. Another way of committing it, you falsely testify in favor of the accused. Both are equally bad. Why? Because there's false testimony. So the question is, how do you punish it? Okay, at that particular point, you're already down there. Tapos ka na ng correctional eh. So you're just talking about arresto mayor or arresto menor. Which of the two? Now, if you feel that one is more serious than the other, then you would do arresto mayor for one, arresto menor for the other. Tama po ba? Do you follow? So, can we settle the issue of whether the penalty should be the same for both instances of acquittal, shorthand ko na lang, acquittal and in favor of the accused? Same penalty?
Yes, Your Honor, because
if that is the case, all you need to do is in the RPC, keep number 1, number 2, number 3, and then you revise number 4. The penalty for arresto mayor, if the defendant shall have been sentenced to a correctional penalty or fine, shall have been acquitted, or if the false testimony is favorable to the accused. Gano'n lang gagawin nyo. And then you have the same penalty for those 3 instances, right? And then the only other tweak that we would do is insert demonstrably, right? So that it's clear that then we're not talking about opinion or bias. And it has to be objective in nature. Do you agree?
Mr. Chair.
Win. Prosecutor
Mr. Chair, even if we include the phrase demonstrably false, that will still be subject to the last provision, Mr. Chair, the necessity of a prior final judgment. That is just my point, Mr. Chair.
With then we could if you give a false testimony in favor of the accused, and that at that particular point is penalized, then you won't wait for final judgment.
Requiring a final judgment is to avoid weaponizing the presentation of witnesses against the. Because if we do not have to wait for a final judgment, then all that the other party has to do is to file cases against witnesses to deter. So I think it's necessary to. That is all, Mr. Chair. That's
fair point, Justice Ampuan.
May I suggest, sir, that the word demonstrable shall just be indicated in the exception in the last paragraph. In all prosecution under the article prior judgment in criminal cases in which the false testimony was given shall be a condition precedent, except when it is demonstrable. Exception.
Justice Ampuan, but that doesn't really address the concerns of Prosecutor Custodia, because it could still be weaponized against to harass the witness. I think that's your point po, tama po ba? Attorney Bilang, Attorney Pangan, ang galing from Congressman Dumogan to me. We're still on Article 186. Okay, proceed. Who was it?
Me.
Oh, there you go.
Since it looks like we're going to the direction already of graduating it, you were batting for the retention of the status quo, right, of the revised penal code?
With revision, subject to revisions. Subject to revisions on number 4.
Yeah, my only concern with that is if you tack in the false testimony favorable to the accused under the 4th paragraph, it's just arresto mayor. So at the end of the day, what's your mens rea? You don't understand or you completely disregarded your oath as a witness. And because it was favorable to the accused, you only impose a penalty of 1 month, 1 day to 6 months. You're still compromising the running of the country, the administration of justice of the courts in particular, and you're working an injustice towards the private complainant. So it seems disproportionate. That's why in my earlier suggestion, we tack that into prison correctional, the 3rd paragraph, collapse the 3rd and 4th one, so that we can address that properly.
So you're saying, so working on the RPC, no? How would you collapse 3 and 4?
The proposed wording of the DOJ, subparagraph 3, and just include there, or if the false testimony is favorable to the accused.
Pero kanina,
yeah,
there was a distinction made between afflictive and correctional penalty, and the view was that they have to be punished accordingly, not imposed. Kasi yung kanina, yung sa number 3 ng DOJ, it collapsed both Parang there's no difference between afflictive and correctional. See? That's why I was working on, if possible, use the RPC as basis. When you revise the RPC, not this one, number 3. You revise maybe, unless you're proposing to collapse number 3 and 4 of the revised penal code. Prosecutor Horda.
I am with the group of the DOJ, and I really respect our stand here. But I also understand the suggestion of Attorney Pangan to retain the provision of Article 180 as separate to Article 181, favorable to the accused, false testimony favorable to the accused, and false testimony against a defendant. Article 180, I would respectfully suggest that it would be false testimony against an accused in a criminal case, but retain the provision. I understand for clarity and simplicity. So, on the stand of Attorney Pangan, to separate the two instead of collapsing.
So, you're saying keep Article 180?
180,
But
only the title
reword the
will
title
be,
because it's
yes.
not a defendant, it's accused.
Yes, accused
Okay,
in
I
a
think there's
criminal
no
case.
any dispute or objection to that. I think not. No.
Yes. But we'll include, sir, the last paragraph that we suggested in our draft, that in all prosecutions under this article, prior judgment in the criminal case in which the false testimony is given shall be a condition precedent.
What about the again testimony favorable to the accused?
Yes, it will be separate. It will be retained, Article 181, false testimony favorable to the accused. The title only will be changed. I think that's more simpler and more
Oh, okay. So
clear.
just let's focus on the RPC para naintindihan.
That's the RPC, yes.
Okay. Number 1 we keep. Number 1 we keep. Number 2 we keep. Number 3 we keep. Afflictive.
Yes, yes.
Number 4 we keep acquittal. Okay. And then you're saying add
To include, sir, the suggestion that in all prosecutions
Yeah.
under this article, prior judgment is a prerequisite.
Okay, that's I see that. I think is anyone suggesting that we shouldn't wait for final judgment? Is anyone suggesting that? No, right?
Your Honor, there is a jurisprudence to that effect, which was mentioned a while ago.
Yeah, but is anyone saying that it shouldn't be like even we don't need to wait for final judgment? I don't think anyone's saying that.
Your Honor, on special cases where the false testimony, as mentioned, is demonstratively false. That's the exemption.
That's why, sir, I suggested that it must be an exception.
Demonstrably false. But what about the weaponization issue that Prosecutor Cristoria raised earlier?
That's why we will still adopt final judgment as a condition precedent. Only that, if it is demonstrable that indeed it's false, then we can without waiting for the.
Okay, because
final
then it's
judgment.
you can say that it was weaponized because it was demonstrably false. Weaponization means that it's without basis.
Yes.
Correct. So if it's demonstrably false, there's basis. So there's no harassment, no weaponization. Attorney Pangan.
Mr. Chair, if I may just comment on the phrase demonstratively false. Demonstrably false. I believe that during trial, the counsel for the accused or on the side of the prosecution can already manifest that in open court. So there's no really harm if we do not include that phrase in the penal code.
Yes. I think we're good with demonstrably false, right?
Yes, yes, Your Honor. Your Honor, just a reaction. You cannot just manifest it in court. There must be tangible evidence showing that the falsity of the statement is really false. Manifestation doesn't work, Your Honor, because manifestation is not an evidence. There must be evidence to that effect.
Okay. So, Justice Ampuan.
Actually, I already encountered the case that was filed before me when I was a prosecutor. And I dismissed the case because there was no pronouncement that indeed the statement was false. So it is really necessary that we have to wait for the final judgment.
As a rule.
As a condition precedent.
Okay.
Except when it is demonstrably false.
Prosecutor Cristoria.
Because this would ultimately fall in the hands of the investigating prosecutor, I think, Mr. Chair, we will need a definition of what is demonstrably,
Yeah,
demonstrably
there's a
false.
need.
If it is false or demonstrably false, it's the same false testimony given in court, which is an attack on the administration of justice. And besides, Mr. Chair, in this particular provision of the law, it is not an element that the court will make a declaration that the testimony is false. That is not an element. The element here is that once the malicious testimony is given in court, then that is actionable. That is all, Mr. Chair.
Your Honor,
Secretary Camara.
the problem on that is that who will say that it is false or demonstratively false? So that as a basis of a separate cause of action. So there must always be a ruling from the court.
There has to be evidence. Evidence. Prosecutor Nahara.
Your Honor, I would like to invite the attention of members of this honorable body that we are debating on whether or not there is a need for a final judgment before one could file a complaint against the false affiant. There is a crimes committed by public officers and rendering unjust judgment that is committed by a trial court judge. That particular article requires that there must be a final judgment before a judge can be indicted for that crime. So, by analogy, can we just use that crime so that we can settle this issue, Mr. Chair?
Here's tama. I see your point, Prosecutor Nahara. Again, to argue for the status quo, or we would say we don't adopt demonstrably. Right? It's just a false testimony. Why isn't that enough? I would venture to predict that if it's a matter of opinion, the court will say, no, that's an opinion. I think when you say false testimony, I think would it help to clarify? Maybe, but it's false testimony. It can't be opinion. It can be political commentary. It's factual in nature. So, ang ano ko lang, because I'm trying to, how do we put an end to this discussion and move on? Sino gusto mag-move on? Ha? Marami po hindi nakaka-move on eh. Diba? So I'm trying to simplify it. Diba? So, you know, just keep 1, 2, 3, 4 acquitted, no? And then add in favor of the accused in number 4. Tama ba? And then the penalty is arresto mayor for acquittal, resulting in acquittal, and in favor of the accused. And then you add the last paragraph, final judgment. Pwede ho ba yun? Hindi payag si Attorney Prosecutor Abadilla, nagtataas siya ng kamay.
Mr. Chair, I just want to say that to be candid to this body, hindi pa po ako nakapag-prosecute ng false testimony case. It's not that, kasi po, pag nangyayari may false testimony, hindi naman po pwede si fiscal yung mag-file ng case. It has to be a third person. Kasi kaya naman po ni fiscal. Kaya lang si fiscal po, masyado pong maraming trabaho. So, hindi. At saka, minsan rin, we don't want to antagonize yung mga parties. So, So, yun po, we're talking a lot about false testimony, but in reality po, wala po masyadong nagpa-file ng case.
Opo, kaya nga, that's why we shouldn't be spending too much time on this. Because either way, it's the same. There's no difference. Right? So, why are we... Dapat ganun eh. So, can we do we have consensus? 1, 2, 3, 4 of the RPC. We just add the term. So, tatanggalin yung or. before shall have been acquitted, and then comma, or that false testimony is favorable to the accused. Di ba ganun lang yun? And then we add the last paragraph. Pero si prosecutor si Dadano, hindi, clarification.
Your Honor, for number 1, we don't have a penalty of death already, so we can skip lang po number 1. It's just my comment po.
Yes. That would be perpetua. Teka, ang ano. So for number 1, let me ask you. I know this is not just for this article. Do you want to future-proof this? Because what if we provide for death later on?
Your Honor, anyway, the death penalty law is just suspended. It was not totally abrogated anyway under our penal system, Your Honor.
Right.
So that can still be, but we have to use that if we intend to use in this provision. All other provisions that imposes a penalty of death, we should apply the same terminology, Your Honor.
That's what I mentioned earlier, because I know this is not a one-off, that this is going to be a recurring concern. Si Prosecutor Ocampo.
The death penalty, why don't we just use capital offense? So to cover also life imprisonment. If the penalty is life imprisonment, we do not have any references to because it's only speak of reclusion perpetua, reclusion temporal. So for capital offense.
Your Honor.
Capital
offense is not a penalty. Capital offense is not a penalty.
No, penalty for capital offense. Penalty for capital offense.
Bakit okay? Bakit hindi okay yung 1 and 2 ng RPC? It says reclusion temporal for sentence to death. Okay, we don't have, it's just suspended, so that's fine. Number 2, prison mayor, if it's temporal or perpetua. Attorney Bilang.
So we can move on. I propose that we park this. Anyway, we agreed to have it a graduated scale. The problem now, or the pending issue rather, is the particulars of it. And the particulars have bearing on other provisions. For example, death. We agreed in Book 1, if I'm not mistaken, to remove that in the list of penalties. So that should be included also. Now that the DOJ has a proposal to revisit those provisions, and I will be commenting on it also, perhaps we can resolve that first, like finalize Article 60 plus, and then move back here once we're done with that. Thank you.
So, in other words, address the fundamental issue first of whether to recognize that as a imposable penalty. Because the effect is, if we include death as a penalty, we are basically, saying that it can be imposed, notwithstanding the suspension. Tama ba? Parang natin we resurrect and revive the death as a penalty. But initially, what was the agreement? That it's not, we should take it out, right? Yes. So, I don't want to, what do you call this? That has already been settled. I don't want to revisit that. I'm not moving to revisit it. So, since we are not revisiting it, then the point raised about, changing, I think it was Prosecutor Horta who raised this, or was it Prosecutor Abadia, that we have to amend number 1 accordingly. Then we have to amend it accordingly, so that it would be tingnan nyo to ha. Again, from the point of view of the status quo, number 1 of the RPC does not apply anymore. Tama? It doesn't apply. Hindi na, because we already agreed in Book 1 that death is not a penalty. Okay? So, tanggal na yung 1. So, ang first paragraph mo, yung number 2 na. Di ba? The penalty of prison mayor if the defendant shall have been sentenced to reclusion temporal or perpetua. Right? What was, okay, in Book 1, was life imprisonment recognized as a penalty? I don't think so. So, that's out. Out po. So, in the old RPC, number 2 would be number 1 na. Would be number 1. And then we go number 3, the penalty of prison correctional, if shall have been afflictive, and number, yung magiging 2 yan. Tapos yung number 4, magiging number 3, the penalty of arresto mayor, if the defendant shall have been sentenced to a correctional penalty or a fine, shall have been acquitted, or if the false testimony is in favor of the accused. Right? Tama? So far? And then, last paragraph, final judgment. Attorney Pangan.
Mr. Chair, I'm sorry kung medyo paulit-ulit, pero I strongly move po for the separate provisions po. For false testimony against the accused and false testimony in favor of the accused, because they have different implication po when it comes to, it depends on the crime.
Okay, how are they different?
For example po, the crime is murder, and merong magte-testify in favor of the accused. But later on, ang hindi na prove is yung let's say special aggravating circumstance elevating a simple homicide to murder. And then the accused would be, let's say, sentenced to the penalty that is intended for homicide. So in a way, the testimony is in favor of the accused, although the penalty is under reclusion temporal or reclusion perpetua. So are we saying that the person who gave that testimony will now be penalized for prison mayor as a penalty?
Yeah, what's the outcome in the case?
Convicted po yung accused to homicide instead of murder.
And what is the reclusion temporal? That would be prison mayor, right?
Yes po.
But he gave false testimony in favor of the accused.
So the person who gave a favorable false testimony,
But
I'm sorry.
Sorry to cut you off. I think that would be irrelevant. Yung ano, in other words, the testimony of the accused was irrelevant, sinasabi mo, to the imposition of the, di ba? Irrelevant. It has to be material.
Mr. Chair, may I be recognized?
Yes, Prosecutor Nohara.
Since we are revising the entire revised penal code, we are talking about the penalty, whether there is false testimony with respect to the penalty. Are we going to adopt a provision that false testimony can only be committed when there is a case or for a crime under the revised penal code? Because it seems, pag nakafocus lang tayo dun sa penalties ng revised penal code, what about the special penal laws na nagpe-prescribe ng life imprisonment, 12 to 20, 6 to 12? So parang walang false testimony pag special penal law. Parang ito yung magiging implication nito kung mag-i-strict tayo doon sa penalty lang. Thank you.
Prosecutor Ocampo.
That is why during my proposal, when my colleague raised the issue that we should delete the number 1 paragraph when the accused is sentenced to death penalty. So, how about if life imprisonment? We are talking here only on reclusion perpetua. So if the penalty that are mentioned under these particular provisions are penalties provided for under the civil code, are we made to understand that if you make a false testimony, that's a special, if we make a testimony for offenses punishable under the special law for which the penalty is not reclusion perpetua, prison major, but life imprisonment or with duration period.
Okay,
so how do we apply this, sir?
But that's a different issue. That's a different issue. Nandun parang tayo sa we're trying to settle first yung how to fix this. So, kanina, kasi Attorney Pan was saying, what if somebody lies, right? But the lies relates to a aggravating circumstance, but eventually the accused was sentenced to was convicted, sentenced. So you would go by. So the question is, are you saying, Attorney Pangan, what? Ito inalo ko eh. I don't know if this would address your or answer your question. For me, the false testimony has to be material. It has to be material.
Your Honor, for me, it's material because it changes the nature of the crime from something very serious to something simple.
So then you go by the outcome. What was the sentence?
My question now, Mr. Chair, is what's the punishment of the lying witness? Is it prison mayor, since we said that if the defendant shall have been sentenced to reclusion temporal or reclusion perpetua, then the penalty is prison mayor, or should it be arresto mayor?
Because he
paragraph?
testified in favor.
Yes, Your Honor.
If he lied to help the accused, right? If he lied to help the accused, dito yung tanong, you could say we're trying to resolve po yung in favor, testifying in favor of the accused. If he lied to help the accused, and then the accused is sentenced to, what was the...
reclusion temporal or reclusion perpetua.
So the question is, did his testimony in fact help the accused or no?
In a way, Your Honor, because instead of the maximum penalty, it will be lower to 1 degree.
Di ho ba ang ito, there's an assumption that so my understanding is if he testified in favor of the accused, right, and his testimony helped the accused, resulting in a reduction, right, of the penalty, then for me that's parang parang di ba arresto mayor yon?
Well, for me, Mr. Chair, if we will separate the two provisions, it will be clearer.
Okay, hold on. Prosecutor Custodia.
Thank you, Mr. Chair. I think, Mr. Chair, this discussion will go back to the point of Attorney Harvey. The law does not really require the lie to be successful. Mm-hmm. Again, it's an attack on the administration of justice. The presiding judge, Mr. Chair, could somehow manage to see through the lie and would appropriately render the decision favorable or against the accused. It does not have to work. The lie does not have to work. It's really the fact that the malicious witness disrupted the administration of justice and injected into the records of the court falsities. That is really the gist of this crime, Mr. Chair. Thank you, Mr.
Yes, and that's why that's a reason why the RPC also addresses the acquittal. Because obviously he lied, but it didn't work. Kaya may acquittal, no? And the reason why we're saying in favor is because in the opening paragraph or opening sentence, it says against the accused. So it's not clear, what about if it's in favor of the accused, what is the penalty, right? And we're saying, if it's in favor of the accused, as a policy, as a expression of our legislative perspective, that an acquittal is like it should be penalized in the same way. And testifying in favor of the accused should be penalized in the same way as falsely testifying resulting in an acquittal. Yun lang naman sinasabi natin eh. So it doesn't have to work.
Yes, Your Honor. So I don't see any major issue if we separate the two provisions po. False testimony.
It doesn't. I don't think it's efficient to do that. It's not efficient because you're just adding one clause. Di ba? So, given that, so okay na po ba yun? So, I'll recap, hopefully for the last time. Itong number 1 of the RPC will be deleted because it does not apply. So, number 2 would be renumbered to 1. Number 3 will be renumbered to 2. And number 4 will be retained with this one revision that we are. So, penalty for mayor, if the defendant shall have been sentenced to correctional penalty or fine, comma, shall have been acquitted, comma, or if the false testimony is favorable to the accused. Yun ang rewording. And then we will adopt the last paragraph of the proposal, prosecution under on this article, prior final judgment in a given case in which a false testimony is given shall be a condition precedent. And also, we will reword the heading, false testimony in criminal case. Ganun ba? No, we're not going to say against because now we're providing for also in favor. Attorney Hernandez.
Mr. Chair, how about the imposition of fine? Because in the original provision, hindi kasama yung new paragraph 2 dun sa magkakaroon ng fine. Ang meron lang is paragraph 3 and 4. So, yun pa rin po yung ifa-follow natin.
You're saying that pag fine lang, that would be the new paragraph 3. Arresto mayor.
Yung nasa original po kasi na text, in cases...
Are you referring to the DOJ or
no,
to
the original text po.
Oh.
In cases, yung after ng paragraph 4, in case provided, 3 and 4 lang. Paragraph 3 and 4 lang. Yung dun po kasi sa revision ng DOJ, lahat merong fine.
Okay.
Opo. Tapos, add ko lang po.
Oh.
Yung dun din po sa Article 181 na original, merong fine pero wala para doon sa second set of offenses. May graduation din po kasi.
181 of the
original 181.
So, and a fine. So, may fine yun. You're saying 181, simply stated, has fine, imposes a fine.
Graduated din po kasi yung 181. May offenses na covered na merong fine. Pero yung latter part, if the and the penalty of arresto mayor in any other case. So pag hindi afflictive yung felony, opo.
Why, if the prosecution, under Article 181, so sabi diyan, penalties of arresto mayor, maximum, to prison correctional, minimum, and a fine not exceeding 200,000 pesos. If the prosecution is for a felony punishable by an afflicted penalty, right?
Yes.
And penalty of arresto mayor in any other case.
Without indication of any fine.
Favorable to the defendant. Walang fine.
in-adapt natin yung proposal.
Hindi. Inaano natin, we are adopting the RPC, keeping the RPC subject to revisions. So, itong Arresto Mayor, okay. Ano ba yung afflictive dito? What is afflictive? What are the afflictive penalties? Prison correctional above. So, prison mayor above. Okay, so that would be, so if you read Article 180 and 181 together, so there would be Arresto Mayor. Kasi if it's in favor of the accused, so how would you reconcile the two? Kasi in the new number 3, itong new number 3, Arresto Mayor na yan. And that's aligned with the Arresto Mayor of 181. You see, Attorney Pangan, you're saying that it should be separate because 181 basically addresses the other issue in favor.
Yes,
Diba?
yes po,
Tama?
Mr. Chair.
Pwede ba natin gawin yon? Because really, I don't want to shake the status quo unless needed.
Retain.
Oo.
Anong binago?
Hindi, ganito lang. Ganito binago, Kong Tinyo. Yung number 1 sa RPC, not applicable. Because wala naman death eh.
Okay.
So, delete yan. Yung number 2, magiging number 1. Yung number 3, magiging number 2.
Change of number.
Tapos, yung number 4, if the penalty shall have been sentenced to correctional penalty or fine, or shall have been acquitted. O yun, ganun lang yun. Tapos you would add, hold on, with cases of 3 and 4. Tapos merong 1, 2. So this would be in cases provided in subdivisions 2 and 3, correct? Of this article. Kasi yung nag-renumber na eh. Yung 3 and 4, 2 and 3 na eh.
Okay.
Shall further not exceeding 200,000. Di ba? Tapos i-add natin yung sa proposal ng DOJ na in all prosecutions under this article, prior final judgment in a criminal case, in which, dito, on page 141, the last paragraph will be added. Just to make clear that this only applies when there's final judgment. So, retain yon, and then...
Pero, actually, that's redundant, di ba, Chair? Kasi sentenced to death na eh.
Hindi, sentence. You could be sentenced, but it's not final.
Ah.
A sentence to prison correctional, reclusion
Okay.
but not final.
Okay, pero why do we want to... Akala ko, DOJ nag-propose dito, kailangan na final judgment?
Because that's what case law says. The cases say that. Tama? It was brought up earlier.
What the, Mr.
Pero yung mga prosecutors, sinasabi nila, mahirap yan pag final judgment. Antayin mo Supreme Court 20 years later bago nila i-resolve.
But what do the cases say? Final judgment. Okay? Opo, Kong Dabangan.
Actually, it was a debate, Mr. Chair, a while ago. Shall we wait for the final judgment, or we make an exception when the false testimony is very obvious? Why should you wait for a final judgment? Because in waiting for a final judgment, it will possibly take 20 years. When there will be final judgment, wala kang witnesses to prosecute the one who made the false testimony.
I think, just to paraphrase the response of the DOJ, correct me if I'm wrong, you're saying that even if it's demonstrably, it has to be prosecuted separately.
Yes.
And also, you would submit evidence, and also there's a concern of weaponization. concern of weaponization that, you know, it could be used to harass a witness.
So, Mr. Chair, as I said, let us define an exception to that. Let's say, example, the witness is in America, tapos sabihin niya nandito, testifying against an accused. Obvious. Dapat sa sitwasyon na ganun, why should we wait for a final judgment? Siguro sa ibang instances.
Who is in favor of carving an exception, making an exception for that will allow the filing of a criminal case for false testimony even before final judgment?
Well, Chair, kasi yung original, it just says sentencing. It doesn't say final judgment.
I think they because they base it on jurisprudence. Am I right? Prosecutor Nahara, as you walk in, yung final judgment hindi ba based on jurisprudence yun?
Of the crime of false testimony, because the judge, Your Honor, in that original case has to determine whether or not that testimony is indeed false for us to prosecute under Article 180 po. Yes, Your Honor.
So, attorney, so ito, okay, in itself, there's nothing wrong with that, di ba? The question is whether we should insert an exception. But with respect to the general principle, you know, general rule, there's nothing wrong with that. It's aligned with the Supreme Court case. So, isisettle lang natin yan, but let's hear from Attorney Barido.
Mr. Chair, as a general rule, hindi po trier ng facts ang Supreme Court. But since inaakit yung mga kaso sa Supreme Court, pwede siyang mag-decide on factual findings ng lower courts. So, magkakaroon po tayo ng problem if, kunwari, sinabi ni trial court, as affirmed ni Court of Appeals, na, itong witness na to, mali yung kanyang testimony. What about pag sinabi ng Supreme Court na, hindi, credible yung kanyang testimony, etc., etc. And then, sa isang separate prosecution, na convict doon yung witness. Right. So magko-conflict ngayon siya sa decision ng Supreme Court. Hahabulin naman yung judge.
I get your point. So you're in effect saying
prior judgment
that
po talaga.
So you wouldn't recommend you wouldn't allow filing ahead of the final judgment.
Yes po. Para po siyang question, para po
because
siyang prejudicial question.
The Supreme Court can actually make a determination whether it's false or not.
Yes.
Correct.
Actually, Mr.
So that
Chair,
ang mangyayari nun is that when you have, when the Supreme Court ultimately says that he lied, yun ang gagamitin mong basis for the false testimony.
Yes, Mr. Chair.
I see the point. Okay. Tama nga naman yun. Mas malinis.
Again, pero ganun ba yun?
Yeah, because they can they can testify on the Court of Appeals or the Supreme Court can actually based on the evidence presented make a determination of whether the testimony was false. So bakit mo papangunahan? Bakit mo papangunahan? Diba? Kaya it makes sense to wait for final judgment. Yun ang...
So, in other words, yung provision na ito ng false testimony is not meant to have a deterrent effect na wag ka magsinungaling. It's more...
Hindi. It is a deterrent effect because it's criminalized. It's criminalized.
It's not immediate, Your Honor.
It's not immediate.
Okay.
Opo.
I think pag-aralan natin mabuti ito. That's why. Yeah, because I am bothered with this one. We should do. This is an opportunity for us to address a problem. Well, it is to say, katama naman, let us wait for the final conviction. But there is also a consequence on that. There's also a consequence on that about the victim of the false testimony. Waiting for a conviction when, as I said, is very obvious. Here is a factual case. Factual case. A witness executed testified na yung address yung akusado, number so and so, barangay in Cabanatuan. Yun. And then meron siyang company na engaged in illegal recruitment. Talagang false. False yan. In the meantime, capital offense yung na-file. Illegal recruitment, resorting to economic sabotage. Na-detain yung akusado kasi unbillable offense. Siya, you wait for a final conviction na
For dismissal.
obvious na kung right. So, again, went to court. It was dismissed. But nag-appeal pa rin yung ku-question pa rin yung mga, that's why dapat let us come out with an exception because this is an opportunity for us to revisit. Tama nga, general rule, I agree. Let's wait, conviction, but I think when it is obvious na talagang mali ang testimony, why should you wait
Can I see a show of hands?
Just to follow the statement of Congressman Dumugon. Worse, Your Honor, when it reaches the Supreme Court, they will not declare that the testimony is false. They will just say that the evidence of guilt is insufficient to prove the guilt of the accused beyond reasonable doubt.
So who's in favor of having an exception for demonstrably false testimony? Raise your hand.
Chair.
Please check.
1, 2, 3, 4, 5, 6, 7.
Chair, if I may add.
Yes, continue.
Well,
Teka, magbibilang pa tayo. Magboboto pa tayo.
sige.
Who's against inclusion of an exception for demonstrably false testimony? Raise your hand.
1,
For qualification.
3, 4, 5, 6, 7.
7. Ano yung kanina? Ha?
10 po pala.
10 yung kanina. Ito, 7. Sinong bumoto ng 2 beses? Wala. Continue.
Chair, ako lang, parang napo-point out dito na parang may kahinaan sa ating justice system with regard to false testimony. No? Na sa karanasan ng mga aktivista, ayan po, laging maraming nade-detain ng napakaraming taon dahil daw, ikaw, well-known activist, nakita ka, nandun ka, kasama ka sa ambush ng NPA sa Mindanao. Samantalang pero many have been detained for many years because of such testimony. Tapos eventually, after 5 years, madidismiss yung kaso. Di ba ganon? Tapos wala namang consequences for the false testimony. So, kailangan talaga,
May exception.
Kasi parang nakita na weakness to, kaya nasasamantala
So,
tuloy.
continue. Just for the record, so you're in favor of carving an exception?
Or rethinking the...
Or qualification.
Ako nga, parang rethinking the whole... For example, kanina may proposal na baka assist talagang penal, punishable pagka false. Kaya ang usapin lang dito, kailan pwedeng i-prosecute.
But you're in favor of prosecuting it immediately if it's demonstrably false?
Maybe.
Maybe.
Have to think further on it.
Okay. Pwede nating Attorney bilang last, and then I will propose a interim solution. Go ahead.
To streamline lang the disagreement, the difficulty kasi po is we're not clear on what the truth is. So, yung proposal ngayon, it puts into the altar the legal truth. What's the truth that was found out by the courts, by final judgment. But perjury statutes really talk about factual falsity. Factual truth. What is the factual truth? So it could be different. Factual truth could be different from the legal truth. So for example,
what's the legal truth?
It's what's found out by the court, but by the evidence.
Truth is based on evidence.
For example, if you are a rape victim, it could be very well been that you have been raped, but you weren't able to prove it. The factual truth is you've been raped, But the legal truth, if found out that there's reasonable doubt, the legal truth is you weren't raped.
Yes.
Yes. So, yung difficulty that we're facing right now is we are putting primacy on the legal truth. So,
Yes.
kasi nasabi natin,
course.
kailangan by final judgment. Now, by putting in an exception, we're saying, but no, for factual inaccuracies, we can deal with it. So, ang nangyayari, we're addressing two different things when we should be clear what really is our perjury statute for. Is it really for running after those who are factually untruthful from the very beginning? Or are we really after every false legal truth that was found out by the court?
But ang sinasabi ko, I'm not sure if this is responsive to your question, is that truth will be vetted by the court in either case. It's just two different routes. One is, in the same case, possibly final judgment. The other one is like separately, but it will go through the process also of vetting based on evidence. In either case, they have to be of a factual nature. Right? Yun ang sinasabi ko. So, but I think what Kong Dumogan and Kong Tinio, maybe, sabi niya maybe diba? Are proposing is carving out an exception for demonstrably false. Demonstrably false that will still be vetted by court. Okay? Based on the show of hands, the majority 10 ba? 10 are in favor of with exception. With exception, carving out an exception. 7 are yes. Tama ba? Carving out an exception. 7 want it as just one final judgment. Okay, so what we can do. What we can do is just let's agree first on let's clean up what we have agreed upon, and then we can post it to the mother committee na lang.
Mr. Chair.
Whether yes,
just one final point. Thank you, Mr. Chair. I think the point raised by Attorney Berido is a serious concern because we will be opening up the possibility of prosecuting a person for false testimony on a testimony which will later on be judged by the appellate court as credible.
Yes.
That is a serious concern.
Yun nga. Yun din ang concern ko eh. Kasi kaya ako, I hear both sides. It's a valid concern. In an ideal world, you want to carve out, you want to be able to immediately act upon something that is demonstrably false, right? But it's gonna, you're risking like inconsistencies in judgment where, as explained by Attorney Barido, who is now raising his hand and wishes to expound.
Mr. Chair, question po sa DOJ. Kailan po kaya, assuming na i-allow natin, kailan po kaya ifa-file itong case for false testimony habang pending yung case ni accused? And then ano pong magiging effect nung outcome doon sa case against kay witness sa hini-hear na case ni accused? Mag-take po ba ng judicial notice si judge sa case against kay witness?
It's magulo eh. Magulo yun eh. Kaya nga ako I really I appreciate the concerns about acting on something that's demonstrably false because it's in your face, no? Pero ang hirap eh. Masyadong you're risking inconsistencies, and also I've been a proponent of, look, dapat our posture should be keep the status quo unless there's compelling and a viable reason, a viable reason to overturn it, to change it. Kasi otherwise, wala eh. Hindi talaga eh. Pero mabuti nabanggit ni Attorney Barido na, which is sort of like I glossed over that. But it is really a valid concern.
So, Chair.
If you have parallel proceedings, one specifically to determine the falsity of a testimony, and then you have the court in the main case actually saying na, alam mo, credible yan eh. Patay tayo. Okay, continue.
Chair, for purposes of this discussion, yung perjury ba kailan pumapasok sa ating batas?
Not in court. It's falsity outside court. Outside judicial proceedings.
So, for example, yung timing ng pag-question sa perjured testimony will be before it reaches court, parang ganun.
Usually mga affidavits, sworn statements.
Okay, so that's under our legal system ngayon. Nyari, yun nga, may nagsabi, nakita kita, sabi ito, mga common cases na merong sundalo, sasabihin, nakita ko lahat yan, yung mga leader ng organizations na yan, nandun sila sa bundok, nag-participate sa ambush, obviously perjured, pero tinatanggap eh.
Sworn statements?
Sworn statements, di ba?
Perjury yun.
Kaya, so dapat dun palang i-challenge.
Pwede nakasuhan ng perjury yun.
Ganon. So yun ang...
In perjury cases, particularly those lies under oath outside court proceedings, we can indict the accused even without final judgment.
Yes.
Mr. Chair. Thank you, Mr.
Kasi you're basing it on the the sworn statement. Hindi kasama judicial affidavits.
Paano kung
judicial affidavits are not included? Kasi judicial affidavits are it's included, no?
So under our system, parang before it reaches trial, pwede kang mag-question for perjury. How about, may trial na, biglang nag-introduce ng bagong witness na perjured, na nagsinungaling. You have to wait until
final judgment.
Yes.
Mr. Chair.
Yes.
But if it is a scenario of someone introducing a false witness, that is another crime because that is presenting a false witness. And in another article.
This is false testimony.
Not false testimony. In false testimony, it is the lying witness.
Like.
But in an instance where someone introduces a false testimony or a false witness, it's another crime.
No, ibig sabihin, the defense produces this witness. Biglang nagsabi, teka, nakita ko, yung defendant,
yes, that's another
inosente
crime.
yan. Ganon. Biglang inintroduce. So, ito, hindi mo na pwedeng questionin.
False testimony.
Pero you have to wait until final judgment.
Then, if you testified as a witness, then you're covered by this article.
Pero ang final judgment pa, hintayin mo muna. No?
Maybe. No. Sana tingnan natin yung requirements of judicial affidavit. Parang you do not wait for the filing of for the actual testimony in court. So long as may under oath na judicial affidavit, mali, parang papasok sa perjury.
Yung tinatanong ko kanina eh.
Your Honor,
yung judicial affidavit.
Judicial affidavit is a requirement
in civil cases
of a court. And even criminal cases, MTC jurisdiction, it's mandatory. Insofar as RTC jurisdiction, it's upon the agreement of the parties if they will use it. That is, the judicial affidavit is in lieu of the direct testimony.
Kasi it's in lieu of testimony.
That's why I'm saying, let us look at that in the somewhat strengthen it, because not only in those cases, it should be all, so that meron kang at least magagawa kung sakaling mali ang nasa, because that will be the direct testimony of the witness.
I think it's are you proposing to mention specifically judicial affidavit? But because as I understand, these practitioners, that it's clear that if it's a judicial testimony in lieu of a direct examination, it is testimony. It is testimony. So for me, it's I don't find the urgency of stating that. Kasi ano ho yun eh, in practice, that is the direct testimony. That is the direct examination. So pagka as long as it is introduced in a criminal case, then pasok yung article applicable.
Mr. Chair, yung problema, as pointed out, requirements of judicial affidavits, like in the subject to the agreement of the parties, not even, there are certain cases na mandatory.
Yes, Your Honor. In cases of summary proceedings, it's mandatory.
So in that particular case, if the parties do not agree to submit judicial affidavits, then there would have to be a testimony. So for this to apply, which is clear. So we don't have to change the language here. I just wanted to point out, Justice Ampuan.
Just to clarify matters, judicial affidavit, if not yet offered in court, can be a subject for perjury.
Yes.
Once it is introduced in court, it can be a subject for false testimony.
Yes. Tama po. Continue.
Ang concern ko na ngayon is, anong proteksyon nung defendant, innocent until proven guilty, from the introduction of false testimony? Kailangan maghintay pa hanggang final judgment.
Yes.
Di ba parang
ideally, in an ideal world, we would want to address that immediately. But the problem is, as pointed by Attorney Barido and shared by Prosecutor Cristoria, is that you don't want parallel proceedings on the truth. Because it's not by design. We didn't wish it this way. It just in other words, we're caught between a rock and a hard place. We're caught between a rock and a hard place. So, given that, the suggestion is just keep it like it as is, because yun ang sabi ng Supreme Court. Now, in the Mother Committee, we can raise that. We can raise that. Or what about if it's demonstrably false? Then we can talk about it at greater length later at the Mother Committee. But I think we have to agree on parang a basis. Okay, what is the basis? Whether it's revised or not? And the basis is this. So we are adopting RPC 180 subject to these revisions. Number 1, delete the first paragraph. Number 2 and 3, right? And then keep 4, right? Keep in cases of subdivisions 2 and 3, right? And then to mirror the case law that says it has to be by final judgment, we'll say it by final judgment. Ganun lang. And then si COMSEC will note that there were suggestions. 7 out of 10, 7 out of 17. Or 10 out of 17 pala. 10 out of 17 feel that there should be an exception to the final judgment requirement for demonstrably false testimony. Dapat ganun lang. Di ba? Then we'll revisit it there. But you will also say, but there were concerns about parallel proceedings, that the parallel proceedings on truth, on verification of truth, parallel judicial proceedings on the evaluation of the truth of the testimony, or truth or falsity of the testimony. Yun ang gano'n na lang. Move na tayo. Kanina pa tayo napako sa 180.
Pero Chair, sa batas kasi, false testimony, pag may sentencing or conviction. Di ba?
Hindi. Dito, yung false, the final judgment refers to the outcome of the case. So, was he convicted of, was the accused convicted of, sentenced to reclusion temporal or reclusion perpetua or
So if there's a
afflictive penalty.
conviction,
Yes.
what if there's an acquittal?
That would be in the new number 1, 2, 3.
In the current law. In the current
Number
law.
4, RPC number 4. Arresto mayor if the defendant has been sentenced to a correction penalty or fine or shall have been acquitted.
Ah, okay.
Okay. Yon. So, ganun na muna gagawin natin, no? So that way, we don't have to, when we present it to the Mother Committee, we have a revised draft already, and then with an additional suggestion or additional point for the consideration of the Mother Committee of whether to carve out an exception. Ganun na lang gagawin natin. Oh. So now, we go to Article 181. In Article 181, ito yung sinasabi ni Attorney Pangan. Di ba? Tama? False testimony favorable to the defendant. So, by the way, sa 180, we will keep the original wording of the heading, except change the defendant to accused. Dito, favorable testimony favorable to the accused. Okay? Any person who shall give false testimony in favor of the accused in a criminal case shall suffer the penalties of arresto mayor in its maximum period, to prison correction in its minimum period, and a fine of not to exceed 20,000. If the prosecution for a felony punishable by afflictive penalty and a penalty of arresto mayor in any other case. Okay. Now, Attorney Pangan, did you raise a point about proportionality here or?
Wala naman po. Actually, ang sa mind ko lang na nakikita kong pwedeng maging cover nito, yung mga family or relatives nung accused na sa kagustuhan nilang ma-acquit yung kamag-anak nila, they would risk giving false testimony in favor of the accused.
Why would that be a consideration?
Okay, Chair.
Continue.
Tanong ko, ewan ko kung may if jurisprudence applies here as well. Ito rin ba, this is also until final judgment? Ganon?
Article 181.
Because actually, walang sinasabi rito.
It is also final judgment. Okay. Prosecutor.
Yeah, both Article 180, 181, so yung present na batas natin, also requires final judgment.
Okay.
Ang exception lang yung number 2, yung civil case. Ang civil case hindi nagre-require ng ganun.
Okay.
Thank you.
So, 181, siyempre, DOJ did not recommend, there's no counterpart of it, because I think you merged it in your earlier drafts. In 186, okay, yeah, right, in DOJ draft 186. But so we have retained, for the most part, we have retained the RPC 180, subject to further deliberation on carving out exception by the Mother Committee. So now we're on 181. Okay, ang tanong ko lang ho dito is if you look at the yung proportionality between, sige, Prosecutor Ricamora.
Just an observation to the provisions so that we can update, Your Honor. With the use of defendant in Article 181, we should use the word accused.
Yes. Yeah, so we will do that. So all references to a defendant are now will be reworded to accused. Opo. The accused. Arresto mayor siya, if it's favorable, and a fine, ito, parang yung favorable to accused is worse than against the accused, resulting in an acquittal. In 180. So, in 180, it's against the accused, resulting in an acquittal, punished by arresto mayor and 200,000, right? Dito, if it's in favor of the accused, right? And then na hindi acquittal pero afflictive siya, Teka, wait a minute. Ano yung correctional penalty? Correctional. Yeah. Prison correctional. So, well, let's say, okay, in number 3 of the 180, if it's against the accused, resulting in prison correctional, arresto mayor ang penalty. Dito, I just want to make sure it's proportionate. Dito, if it's in favor of the accused, resulting in afflictive, so worse, no? It is arresto mayor, maximum to prison correctional. Bakit bumaba? Hindi, tama. Mas mabigat siya, no? Mas mabigat. And penalty of arrest mayor in any other case. So, pag correctional lang, aligned naman siya. Do you agree? To me, it's aligned. Okay.
Aligned?
Aligned. Parang yung, kasi in number, consistent. In other words, it's graduated depending on the outcome also. Appropriate, tama po. Salamat kong dumogan. So tama, do you agree it's appropriate? Okay. Parang may tumututol sa taas, ha? Sabi, tama ka. Okay, so we're keeping 181? Huh? Okay. So we're adopting 181? Thank you. Oh, before that, okay, Prosecutor Ciudadano.
Your Honor, to be consistent with Article 180, we want to also copy in all prosecutions under this article, the prior final judgment is still there, Your
Good
Honor.
point. Any objection to that? There being none, we're adopting the suggestion. Going now to Article 182. Oh, nakakadalawa na tayo. Congratulations, ha?
So essentially, ang amendment lang, Chair, is itong addition of in all prosecutions, tsaka
Yes.
yung pagtanggal ng
Opo.
ng death penalty.
Opo. Tsaka yung ma-rewording references to defendant are now references to accused.
Okay.
And then with the, further consideration of carving out for demonstrably false testimony that may be acted upon immediately, that may be prosecuted immediately.
And
Okay.
the reason for the addition of in all prosecutions is to make explicit the jurisprudence.
Yes.
Ganun ba yun?
Yes. Hindi tayo nagkakamali sa jurisprudence, ha?
1941 pa yun eh.
Huh? Okay. So now we go to false testimony in civil cases. Okay, should we, let me see. Okay, to the DOJ, how is this draft different from the RPC?
The addition, Mr. Chair.
Of the false,
Yes, prior judgment, Mr. Chair.
because you feel that it's, if you require final judgment in criminal cases, what's the point of not requiring it in a civil case? Yes. Yes? Prosecutor Abadia.
Thank you, Your Honor. We are of the opinion also that we may remove this because based on the decision of the Supreme Court, it only applies to criminal cases. However, this is for civil cases.
The Supreme Court said that Article 182 only applies to?
In relation to Article 180, Mr. Chair, we wanted 180 and 181, we wanted the last paragraph to be retained. However, there's
You're talking
no,
about just you're referring. Are you referencing the RPC or your draft?
in the draft, Mr. Chair, it's Article 187. It still includes the last paragraph which says in all prosecutions under this article, prior judgment in the civil case.
Okay.
Considering that the case of People versus Maneja is only applicable to criminal cases, Mr. Chair, we can remove this in this
Okay.
This article.
So you, in other words, this applies even prior to final
Yes.
judgment
Yes,
in a
Mr.
civil
Chair.
case.
Yes, Mr. Chair.
Pero, Chair, okay, I understand the basis. Sabi,
Yeah,
yung
alam ko na
jurisprudence
tatanungin ko ang
applies
opinion.
only to a criminal case. Pero,
So why do you make
pero,
a different
raise
distinction?
natin yung point ni Attorney Barrido na hindi ba nag-a-apply din yun na...
Competing assessments of
Oo.
truth.
Mr. Chair.
Oh.
Yes, Prosecutor Custodia.
This is in defense of the proposal of the DOJ. I think the same as the reasoning of Attorney Barrido, Mr. Chair, the civil action in this particular instance is a prejudicial question, holds a prejudicial question on the criminal aspect, because the element of materiality is an element in this particular case, and there is no way for the prosecution to determine if the supposedly false statement is material or impacted on the outcome of the case unless there is a final judgment in the civil case.
So you're batting for
I am
final
supporting
judgment.
the proposal
Oh,
of the DOJ,
Tama.
Your Honor.
But ano yung sinabi ni Prosecutor Abadia? You, Prosecutor Abadia, you were batting
independence of
for
mind.
deletion of the paragraph.
Yes, Mr. Chair.
Why?
It's included here. However, when we were discussing a while ago during the break, we already thought of it. What's the difference between the previous articles and this Article 187?
And what's the difference?
So, our basis for the previous articles was the case of People versus Maneja.
Yes.
But there's no basis for this particular provision, Mr. Chair, that it be applicable to civil cases as well.
Okay, but
Yeah.
but the rationale also applies.
Yeah, but yes, I agree, Mr. Chair.
So you are in favor of making keeping your final. Magagalit sa'yo si Prosecutor Custodia.
Pareho pa naman kami ng plane mamaya, Mr. Chair. Baka hindi ako tabian sa plane.
Oo, lagot kayo.
Di ba nakatayo siya?
Sino mas senior sa inyo?
According to age.
Marunong sumagot,
Hindi,
Mr.
kaibigan ko
Chair.
yan, Mr. Chair. Siguro kasi malayo lang kami sa isa't isa ngayon.
Mr. Chair.
Opo.
There is also the same concern of a judicial contradiction if we allow a simultaneous proceeding in the criminal and the civil case, Mr. Chair. We wish to avoid that particular situation by adding the final provision in this proposal. Thank you.
Yes.
The basic distinction which is in my mind right now, Your Honor, is that insofar as Article 186 is concerned, Your Honor, there is the right to liberty is at stake, but not in Article
187.
187, Your Honor.
Well, right to property might
No, but
be at stake.
I think
But insofar as the ladders of right that is more compelling and more important.
Pero due process still
Mr. Chair.
applies, di ba?
pero sa akin po yung kanina, I think what the most how do you say this? The parang what was strictly the thing that hindi ako makapagsalita. Yung talagang tinagalog bigla. Yung talagang matimbang na argument kanina, yung binanggit na yung competing or parallel judicial assessment of the truthfulness of the truth or falsity of a testimony. I think it's that eh.
Yes, Mr. Chair.
So yung one is criminal, one is civil. Parang it's not strictly relevant to the discussion for me. So in any case, I think that DOJ you're aligned already. You're on the same page with respect to requiring final judgment to be consistent with a criminal case.
Our only concern was that we don't have a basis, but considering that
The basis is that that there's no difference between
criminal complaint, affidavit, or sworn statement falsely imputing the commission of a crime upon another person, and I want this be inserted, or by providing a false address or false identifying information of the person falsely imputed in connection therewith, and the penalty prescribed by law for the offense falsely imputed is higher than prison mayor, in its minimum period, the penalty to be imposed shall be equivalent to that prescribed by law for the offense falsely imputed. So that's the, I am happy that Prosecutor Nahora, one of the few cases that we did handle, knew very well a person by the name Attorney Patrick Caronan. Because these recent cases, there are 4 graduating law students of University of the Cordilleras who happen to be the classmate of the wife of Attorney Patrick Caronan from Bayongbong, Nueva Vizcaya. Then, because of jealousy, he had been threatening the classmates of his wife that sinususpitsa niya, siyota mo ata yung aking si ganito. And then, of course, they are denying it, and he said, I will find every means to see to it that you will not graduate in the College of Law. They did not give serious attention to it because they were not doing anything. All of a sudden, warrant of arrest arrived. One of them, who is a teacher at Baguio City National High School, had been arrested. The information that had been filed is illegal recruitment resulting to economic sabotage, which is a capital offense. He was arrested, detained in the regional jail in Cabanatuan City. The other 4 were not arrested except one. So, when we were finishing the case in Palayan City, there's another case, similar nature, filed in Cabanatuan RTC, with other 3 cases also in the Municipal Trial Court. The same unbillable offense. When we were about to finish it, there's another one in San Jose City. Similar allegations, different complainant, but providing the same address in Cabanatuan City. When we were about to finish it, there's another case in Binyan, Laguna. Similar allegations, different complainants, the same false address. There's another case in Santo Domingo. So talagang a lot of cases. Later anyway, the first that was arrested had been exonerated. The person of Melvin Jose Alamag. Then, fortunately for the other 3 accused, the director of the NBI, and I'm thanking the NBI, of course, regional office, Cordillera, because they accommodated our request that we surrendered them to their office. They will be detained by their detention center and allow them to take the review while they were in detention. Fortunately, one of them, Jennifer Noto, passed the bar exam last 2024 because these are recent cases. Now, and later on, after 6 months, they were all exonerated. Well, Jennifer Noto was not immediately allowed to take her oath because of that another municipal case in Binyan, Laguna And then we waited up because walang judge. Then it took us many additional months before it was dismissed, and that was the only time she had taken her oath. Now, you filed the case against this Richard Patrick Kalunan, but again, billable offense. It was only prison mayor minimum period yung penalty. Whereas the accused had been languishing in jail. So talagang very unproportionate. And I think we cannot prevent one from doing it unless we introduce this kind of amendment to hopefully prevent certain individuals from filing a fabricated offense. Well, as Attorney Prosecutor Nahora has known, he prosecuted this Karunan. He was convicted, but he jumped bail. But this was disbarred by the Supreme Court. Talagang magaling ito. It was discovered that he used the diploma in transcript of, because he did not graduate, bachelor's degree. Ngunit magaling. He entered PMA in 1993, but after 2 years, he was dismissed kasi loko-loko. And then he had stolen the transcript and diploma of his younger brother, Patrick. He went to Bayongbong, Nueva Vizcaya. He enrolled there. He passed Bachelor of Laws. He took the bar. He took it once. He passed the bar. I think, I cannot remember now the year. The one that complained is no less than his actual brother, Patrick, because he had been committing a lot of offenses. And then one of the offenses hired the Quasa Law Office as their lawyer. Sinulatan ito si Patrick Karunan, who happens to be a manager of, I think, 7-Eleven in Makati. When he received it, he was shocked. Then he discovered it was his brother. So he filed the disbarment case against his brother. If you read the decision of the Supreme Court, the Supreme Court narrated what he had done. He was disbarred by the Supreme Court. Despite the fact that he was disbarred, he was still practicing law in some areas. He victimized somebody in Quezon City, owner of his municipal, by selling a fake title. They filed another disbarment case, but the Supreme Court said, what are we going to disbar? He is not a lawyer. He was already been disbarred, said by the Supreme Court. Well, we filed a perjury case against him. But, well, I do not know if it's God's will. Death sentenced him, COVID sentenced him in April of 2020, I think 2022. So, we did not, that case did not pursue. Such thing. Well, I have been handling in the 1970s similar case, but these were the worst cases that I handled. Well, the fabricated complaint accusing somebody of an offense that carries with it capital punishment. So, I hope our very intelligent resource speakers will support us on this point. And we will not last 4 hours more in debating.
Kong Dumogan, this question. Earlier, when you read your proposed revision, which are capitalized here, you inserted additional language. Ano ba yung...
I included this one because I had the chance to talk with the Secretary of Justice, Secretary Vida, and he suggested that you include also this one.
False
Kasi yung
language,
una,
false address po.
yeah, giving false address. Kasi that's exactly what Karunan had done to my clients. He had given an address in Cabanatuan City with this barangay, with this number. We went there. That number did not exist. The barangay captain certified that walang residente ng aking barangay ng mga ganong tao. And then that given the alleged that our client as a owner of a recruitment company na wala naman. Yun yung ano. So, we had discussed this with the Secretary of Justice. Siyang nag-suggest dyan. So, I added it.
Your Honor. Your Honor.
Prosecutor Gamora.
Just to, we find nothing wrong with the inclusions of the proposal of Representative Dumogan. But just for the information of our fellow Ilocano from Baguio City, insofar as address or false addresses given by complainants in filing criminal cases, there is now a new rule under issued by the Department of Justice that we now require that whenever they provide an address of the respondents, it should be under oath already. Unlike before that you can just provide anything there in your information sheet. But now, we strictly make sure that they know the address is existing, and that is in an affidavit form.
So the address, just to clarify, the false address pertains to the defendant.
Yes.
That's
why the defendant was totally deprived of due process, Mr. Chair. I fully agree with the Kamon. We sent DOJ memorandum requiring that, but unfortunately, walang nakalagay na penalty. That's why we included it here so that it should be one of the elements that will be subject to a penalty. Actually, I do not know the take of, especially the Department of Justice and the prosecutors. I'm about to add, how about the prosecuting fiscal who will negligently file the information without complying with that requirement of the Department of Justice? That will result to a situation wherein the accused will be detained. Later on pala.
So what happens, just so I understand?
But I will go to that later. Concentrate natin muna sa
It's not providing the false address. It's not the false address of the complaint. It's the false address of the respondent or the
Yes, the respondent.
Because so that you can it will result in default, diba?
Yes, Your Honor. So that they cannot file a counter affidavit.
Magiging just based on the evidence of the complainant. And then in the meantime, since the defendant defaulted, this is also for the benefit of the viewers. It's information is filed in court, and then a warrant of arrest is issued based on one side of the the evidence. Okay, Prosecutor Abadia.
Thank you, Mr. Chair. So we are not oblivious to this practice of unscrupulous individuals. However, that's why the Department of Justice drafted and passed the memorandum, Department Circular DC-15 to address this issue. As of the moment, it is already required that prosecutors conduct preliminary investigation. The purpose for that is to ensure that the complainant really gave the correct address. So and then when the respondent receives it, then the respondent will appear during the scheduled preliminary investigation conference and then file his or her counter affidavit, because we know that hindi nila alam na may case sila. tapos nakakatanggap na lang sila ng warrant of arrest.
Maraming ganyan.
Yes,
Madami yan.
sinasadya
Kahit
po
sa
nila.
Bataan, maraming ganyan.
Yes, sinasadya po ng mga complainants na ganyan ang gawin kasi alam nila na kapag wala namang counter affidavit, the prosecutor is bound to resolve it anyway.
Yes.
Tapos sabihin uncontroverted yung evidence ng complainant. And to answer your question po, Kong Dumogan, about paano pag in conspiracy with the prosecutor or the prosecutor is also corrupted. Wala po akong maisip na penal sanction as of the moment, but definitely po yung prosecutor will be administratively liable. Tapos pag may kasamang pera, syempre, Anti-Graft and Corrupt Practices Act po.
Actually, Mr. Chair, thank you. I said, yes, I am aware of the latest memorandum of DOJ to that effect. But look, it does not carry a penal provision. Walang penalty, only administrative. And that is, that's why we included it here so that it will, carry a penal provision. That's one. We will discuss later on what are we going to do, as you said, with the prosecuting a prosecutor who will negligently do his job by not following even the memorandum of the Department of Justice. But we'll take that later on. Shall we consider him as liable also? Oh, but as I said, let us concentrate.
Let's concentrate
Only on this one.
Prosecutor Horda, and then I have a question for the
I
group.
hope you will not vent it on the prosecutor. There is such thing as presumption of regularity, Your Honor. And also, with regards to what kind of case could be filed against that person, it could be perjury because in the complaint affidavit, he will already mention the address of the accused, so or the complainant or whoever is subject for subpoena, then we can already file a case for perjury if the address is not the real address. Perjury because it is a sworn affirmation.
That's exactly what the amendment is saying.
I have a question.
Yes. What the amendment is saying is there's perjury that we can file, but yung penalty should not be prison mayor minimum. It should, if the penalty for the fabricated offense is more than or heavier than prison mayor minimum, then it should carry the penalty for the fabricated offense. So that we balance, there will be an appropriate penalty. Na-detain yung akusado, pagkatapos ihabla mo yung nag-fabricate, is a billable offense. Yun. So that's the intention of the said bill. That's why, as I said, di naman controversial eh.
I have a question. It's one thing to falsely impute a crime, right? It's another thing to falsely state your address. So, for a false imputation of a crime, I see the point of like an eye for an eye. If you accuse somebody of falsely accuse someone of, say, theft, right? Whatever the penalty is, then you should be meted out the same penalty. I see the fairness there, no, or the justice. But with respect to falsely indicating the address, do you think that it should also merit the same penalty? Na kapag theft, whatever the penalty for theft is, then you will impose also the penalty of theft for the person who falsely states the address of the respondent.
Well, to me, it should be. It should carry the penalty for the fabricated offense.
Because
if the penalty for that fabricated offense is higher than the penalty provided for the present law, which is prison mayor minimum.
Oh,
That's the ano.
And the point for that, I think the reason for that is because it will result in a default. The respondent will default, and therefore, based on one set of evidence, that he will be criminal complaint will be filed in court against that person. Yun ang tingin ko. No? But Attorney Bilang.
Sana po hindi magalit sa akin si Congressman Dumogan.
Teka, hindi ka na maabot ni Kong Dumogan eh. Malayo ka naman.
Just want to point out two things on the proposal. First, on the false testimony that we just approved, if the person is gives a false testimony and the accused was convicted to a reclusion temporal or reclusion perpetua, which is also non-bailable, the penalty imposed upon the one who lied is just prison mayor. Now, we're saying, if you make a false affidavit, complaint affidavit, that imputes a crime of reclusion perpetua, you should also be subjected to reclusion perpetua. So, you have someone who's lying in court, prison mayor, someone who's lying under oath in an affidavit, reclusion perpetua. So, there might be disproportion there. My second point is, I understand the danger of false imputations of crime. Attorney Pangan was just telling me over the break that she notices that I'm for the accused, so I know that there's really a danger of false imputation of crimes. But we might have to take a step back and not just focus on this one particular individual who's unscrupulous, admittedly unscrupulous, and think of the larger picture. This will apply to everyone. When I read the proposal, it seems to me that there's a lot of danger there. For example, if you are a complainant for rape, the penalty for rape is reclusion perpetua. If that case ends in an acquittal, if you're the accused, you have the right to say that complaint is fabricated, right? That's a false accusation of a crime against me. Now you have a situation where the complainant can be subjected to a perjury case, the penalty for which is reclusion perpetua as well. Parang nauno reverse card si complainant. So you have that danger. If you are a complainant, will you now still complain? Because the danger is, at the end of it, baka mamaya ikaw ang ma-reclusion perpetua. Hindi na lang ako magko-complain. I'll just keep silent. Diba? So yun po yung danger in the proposal that I'm seeing.
Mr. Chair.
Prosecutor, who was first? Nohara and then Cristoria.
Although my name was mentioned by the Honorable Dumogan earlier, because I also...
Prosecutor Horda, papatay po the microphone. Thank you.
Because I have also prosecuted that person, Patrick Dumogan, for violation of 10591. Now, regarding the proposed draft of Congressman Dumogan, it appears that this is a special form of perjury, because the general concept of perjury is when you lie under oath, it is on a material matter, that is perjury. Okay? So, parang special form of perjury to that specifically applies to a complaint, criminal complaint, in the allegations of which are all falsities. So, what is the rationale if bakit lang sa criminal case lang? What about if labor case, mag-file ka rin ng false complaint? Or administrative case? So, is that covered by Article 183? Yes, it is covered. So, yung nag-file ka ng criminal complaint and later on, false pala yun, it is already a perjury since we have a jurisprudence with respect to that. So why are we going to specify it na pag nagkaroon ng imputation of a crime, that is also a perjury na? So, covered na siya by existing jurisprudence. When sabi ng Supreme Court, when you executed two inconsistent affidavit complaints, that is perjury, provided you must prove which of these two is false, which of these two is correct. So, bakit pa natin magbibigay tayo ng special provisions on this? Because ang pag-impute ng crime is already a libel. That is libelous under Article 355 of the Revised Penal Code, 354, that when you impute a crime without legal basis, without factual basis, that is libel, Mr. Chair. Kaya parang redundant na to eh. With due respect to Congressman Dumugan, why are we so particular sa criminal case when it is already being covered by existing jurisprudence? Thank you, sir.
And libel.
Yeah.
Kong Dumugan.
Yeah. Well, sa cited na labor cases, wala namang penalties, penal provision yung ano sa labor cases eh. That's why it's really a special provision that address a particular situation wherein the fabricated complaint carries a heavier penalty than what is imposed in the general provision of the perjury law. That's the situation here. To at least commensurate with what had been committed by the complainant. Now, going to what had been pointed by Attorney Bilang regarding a rape case. Well, again, we had agreed previously that subject to the final determination of the said case, and if it will not come out na fabricated, obvious na fabricated yung complaint, I am sure this will not cover the situation. But in the event, maliwanag na talagang fabricated naman yung affidavit complaint against the accused, then this provision will apply. Because if we do not address this one, I'm sure this is going to continue. I can remember handling not less than 10 cases of this nature. One filed in Bisaya, when the accused is from Mountain Province. Of course, we all know that they provided the false address in the Visayas. But when the warrant of arrest was issued, it's all over the Philippines. It's not only in Visaya. Nagulat lang siya na pinaccuse of a capital offense.
Attorney Bilang raised another point about, proportionality, because in the previous section he was talking about, false testimony, which does not meted out the penalty for the crime, the penalty meted out or on the accused, no? Kasi so let's say the complainant, obviously, when he testifies in court, he is falsely imputing the crime because he is the complainant. So how do you distinguish between false testimony on one hand and falsely imputing a crime or perjury in this case, where in the former, or in the case of false testimony, the penalty for false testimony is not as heavy as the sentence, right? And here, the penalty for perjury is as heavy as the sentence.
Mr. Chair, I do not know if you can see the difference. The difference is, look, in the first one, false testimony which is given in court, that was not the one which resulted in the filing of a case. In this particular case, the perjury had been executed that resulted to the filing of the information that carries with it, I repeat, higher penalty than what the present provision provides for perjury. That's why that will, as I said, in a situation wherein the complaint, the fabricated complaint carries with it capital offense, unbailable yan. Nakulong yung akusado. Oh. And As I said, these have been happening. So this
Mr.
must
Chair,
be addressed.
Ito, before prosecutor, so before we take other comments on the proposed revision of Kong Damogan, ano ko lang, I'll just clean up, because that's paragraph actually 3. Can we just talk about? I just want to talk about paragraph 1 and 2 first, so maybe we can get some consensus there before we talk about the third paragraph proposed by Congressman Damogan. Yung first paragraph, Kong Damogan, yung first paragraph, your first paragraph is the same as the first paragraph of Article 183 of the Revised Penal Code? Pareho po. Pareho, no? But in the DOJ draft, you propose to lower the penalty, no? Prosecutor Ciudadano. Prosecutor Ciudadano.
Your Honor, I think there was just a oversight in copying the penalties because this has already been amended by RA 11594. So the correct penalty should be prisión mayor
in its
minimum period, Your Honor.
Okay, so how...
Minimum to medium.
So with respect to the first paragraph of Article 188, as you proposed, how is that different from the first paragraph under the Revised Penal Code?
Actually, there's no difference,
Okay.
Your Honor, if we just copy the penalties.
Okay, so pareho yan.
Yes.
Let's talk about the second paragraph first. Next. Your second paragraph, well, this is to... Well, no, let's talk to the DOJ first. Your second paragraph, how is that different from the second paragraph of Article 183? Prosecutor Nara.
As confirmed by Prosecutor Kim, I think there was oversight on this on the part of the DOJ. We should have copied RA 11594 because it is the recent legislation with respect to perjury. So we'll just adopt the present wordings of the Article 183 as amended by RA 11594.
So the second paragraph as appearing on
Yes,
the
Your
first
Honor.
column, left-hand
As
side,
the first column.
is you're adopting in total?
Yes.
In whole?
Yes, Your Honor.
So, and I believe, Kong Damogan, you did the same, ano? You adopted the first and second paragraphs of Article 183. Okay, so malino tayo. At least we have some consensus, no? Dalawang paragraph, dalawang pukpok. O yan. Pasok tayo dyan, ha? Now we'll talk about the third paragraph, okay? Maybe hear from Prosecutor Custoria.
I think the scenario provided in the proposed third paragraph, Your Honor, is more than being a crime of perjury. This is malicious prosecution, Your Honor.
Malicious prosecution is a civil case in the civil code, no? It's for damages. And I guess in the civil code, malicious prosecution, you can only be prosecuted for malicious prosecution when upon acquittal, if I'm not mistaken. Tama po ba? Okay. Yes.
Your Honor,
Prosecutor Camora.
the amendments introduced by the Honorable Damogan is, to my mind, akin to the provision of Republic Act 9165 or the Anti-Drugs Law on planting of evidence. It says, any person who is found guilty of planting any dangerous drugs and or controlled precursors and essential chemicals regardless of quantity and purity shall suffer the penalty of death. For instance, you planted an evidence and made it appear that the person is selling prohibited drugs. The penalty is life imprisonment. So it's a capital penalty. So the law penalize the offender on the same penalty as that was charged against the person. I think that is the analogy made by the Honorable Damogan.
Kong Damogan and then Attorney Bilang.
Yeah, I think to somewhat include here, we can include a provision which state that the fabricated complaint or providing false address resulted to the filing of the fabricated case, because in the previous paragraphs it refers already to proceedings in court.
Mr. Chair, Mr. Chair.
Who was first? Attorney Bilang was first, and then prosecutor. Sino ho sa inyong dalawa? Custodia.
RP.
Yielding to Medina Padilla, but Attorney Bilang first.
Yeah,
and also there's a thing
just
about
on-
libel, and libel, whether that's sufficient or not.
I think the analogy of Prosecutor Ricamora earlier is not that on all fours, in a sense that it's planting of dangerous drugs is punished heavily because it's imposed primarily on public officers. You're a public officer, you're a policeman who's supposedly getting that person, right? Tapos nag-plant ka ng evidence at saka ang dali eh. Ang drugs ang daling isuksok sa pocket ng individual. It's not the same as making an affidavit imputing, albeit falsely, a crime to another person. So I think we're just now disagreeing on the proportionality of penalty. For me personally, reclusion perpetua should be reserved to the worst of the worst offenders. Murder, rape, anything else should be less than that.
Totoo ba? Okay na, tayo po tayo dahil meron po asyon din. Prosecutor Elmido.
Thank you, Mr. Chair. I somehow I agree with this kasi kakawawa ka naman. I-impute ka ng crime and non-bailable tapos it turned out to be fabricated. Ang question ko lang nito is, when do we determine it is fabricated? Does that mean na tatakbo muna yung kaso? Pagkatapos na-acquit, saka pa niya magpa-file kasi fabricated. So, kailan ma-determine yun? Thank you po.
As already been, yes, because as already been agreed a while ago, final result of the case. But the most important here is the execution of the document which results to the filing of that's one. And that can only be filed after, final
judgment.
Mr. Chair.
Who was next? Prosecutor Abadia, and then Prosecutor Sidano.
Thank you, Mr. Chair. I just wanna raise this concern kasi po, nabanggit ko a while ago, may mga unscrupulous complainants, pero meron din po mga unscrupulous respondents. What am I saying? Nangyari po sa amin na the respondent pretended that he did not receive the counter affidavit. The complaint affidavit. He's saying that it was not served in the right address, but subsequently we determined that he actually was the one who received the registered mail. So in cases like this, the respondents can also file a case against the complainant based on baseless complaints. He's claiming that he did not receive, but actually he received. So maybe we should consider, kasi it's suggested that we include na pag false yung sinabi na address. Maybe lighter yung penalty kung there's a determination of false address compared to pag nag-impute talaga ng crime na masyadong mataas yung mga penalties, Mr. Chair.
Yeah, just clarification. You said earlier that if the respondent provided, the complainant provided a false address of the respondent, no? That the respondent could sue him for that, right? Okay. I just want
Mr.
to Prosecutor Cristoria.
Thank you, Mr. Chair. We are in the topic of perjury. The mention of a false address being provided by the complainant, that's really a bad situation in the conduct of preliminary investigation. But as mentioned by Professor Nohara, Mr. Chair, materiality is an element in the crime of perjury. So if the complainant provides a wrong address, but the complaint is about estafa, how is that material to the crime of estafa? So we cannot indict the person for the crime of perjury. That is just my
I
point,
see the point,
Mr.
because
Chair.
it's material misrepresentation of, the address is not material to the crime alleged. Other views? Yung sa false imputation, yun, pwede. Diba? Kasi you lie under oath. Diba? Prosecutor Nohara.
Your Honor, the basic distinction between falsification and perjury. In perjury, it must be under oath. In falsification, need not be under oath.
Correct.
Yes, Your Honor. Just view. That is my view.
So let's see. Let me break down the third paragraph. Okay, we've heard both sides, both sides in support of course, mainly from Kong Dumogan, on why the false imputation of a crime should be punished, and that it should be punished by imposing the same penalty in the crime imposed for the crime alleged. And he also proposes that if the complainant provides knowingly provides a wrong address, that the complainant should be imposed the same penalty as well. Correct? Okay. You saw what there was a suggestion to lower the penalty. So just on the first issue, of the falsely impute a crime against someone, you should be
That resulted to the filing of the...
That results in the filing of the complaint. That you should... of course, yung falsity will be determined in the final judgment, upon final judgment. Right? Kasi, gano'n yan eh. Same like sa malicious prosecution, gano'n din eh. So, who here feels that there's a need to specifically criminalize this? Okay, we've heard from prosecutor sa false imputation of a crime. Kasi parang Kong Dumogan believes that this has to be specially addressed, and that existing perjury statute is inadequate, is not enough. So, who feels the need, let's show hands lang, who feels that this should be specially addressed? Itong false imputation of a crime.
Chair, what does false imputation of a crime mean?
You know that there's no basis for a crime, and that you fabricated here, you executed a fabricated criminal complaint or an affidavit or sworn statement, falsely imputing the commission of a crime. Parang criminal complaint. You lied in a criminal complaint.
Well, lying is different from making an accusation that doesn't stand up in court.
Yes. So, in other words, you're imputing a crime to a person. So, I would think that...
Filing a complaint is imputing a crime?
Oh, but if you know it's baseless. In other words, it's the elements do not exist all the elements do not exist, and you file it.
Mr. Chair.
No, but any acquittal will means there was no sufficient
Yes.
basis for a conviction.
So sabi ni-
pero
kung-
pakicriminalize ka na.
Kung Dumogan feels that if you know that the complaint is baseless and you proceed to file it, then you should be meted out the same penalty as the underlying crime. Yung tama po ba, Kong Dumogan?
Yes,
But
Mr.
Kong
Chair.
Dumogan can explain
The
further.
elements will be, number one, you executed a fabricated complaint. That will result to the filing of an information. That's number one element. Second, that the information or the case that had been filed carries a penalty heavier than what the existing provision provides, which is, in short, higher than prisión mayor minimum. So that's those are the two indispensable elements. Then, of course, number three is na-acquit yung akusado.
Mr. Chair.
Mr. Chair.
Would that not be already an instance of incriminating an innocent person, Mr. Chair?
Incriminating an innocent person.
An innocent person.
Incriminating innocent person, doesn't that contemplate planting evidence?
Yes, same thing, Mr. Chair.
But is planting evidence, okay, just for purpose of discussion, is planting evidence the same, or how is it different from filing a false information, or false complaint? Prosecutor Sidano.
Your Honor, for planting of evidence, I think since it is an overt act, it will fall under the incriminating an innocent person. But if it is, it will be covered under Article 183 if it is under oath. For example, the affidavit. So it must be under oath. So
Correct. I understand. I understand the distinction. One is under oath, one other isn't. Right. But I'm more focused on the penalty. Kasi yung isa, incriminating is, what is the penalty for incriminating an innocent person?
Arresto mayor.
Arresto mayor.
Yes.
Here, if the penalty for the underlying crime is higher than prisión mayor, then it's whatever the penalty for the underlying crime that will be imposed on the person who who falsely imputes a crime.
Let me go to an example cited by Attorney Harvey earlier. For example, may nag-charge ng rape, nag-accuse ng rape. Sabi, posibleng nangyari, pero hindi napatunayan. Beyond reasonable doubt. Will that fall under yung, ano yung tawag nyo? False imputation of a crime? You were not able to prove it.
No.
You were not able to prove it. O, paano yun?
Your Honor, to answer that.
Prosecutor Gamora.
Your Honor, to answer that, it will not be covered because more or less at least you have some basis, only that you were not able to discharge the required quantum of evidence.
Ngayon, yung sa discussion...
Insofar as fabrication, that is a framing an allegation and evidence in order just for the sake of filing case to vex him or to disturb his peace.
How or when will that be determined? Kasi sabi ni Rep. Dumogan, nag-fabricate ako ng complaint and then an information is filed.
A concrete example can be
hindi, ako lang, ang point ko lang, hindi ba dapat yung prosecutor, yun ang isang dapat niya gawin. Teka muna, parang fake to
The only problem is that if the person was not summoned or the subpoena sent to the person was not received by the respondent, the prosecutor will be forced to determine the existence or non-existence of prima facie evidence of reasonable certainty on the basis of documents, allegations on record only. So it is more or less summary already on the part of the prosecution. We will be just basing our recommendation on the pieces of evidence on record. Thank you, Your Honor.
Well, that's actually not probable cause. It's reasonable certainty of conviction. Prima facie of reasonable certainty of conviction.
Pero yung the false the complaint can only be considered false imputation
upon final acquittal.
Upon final acquittal.
Yes.
Your Honor, the proposal of Congressman Dumogan can also be illustrated like this. I'm a candidate, for instance, for mayor. We are opponents. Kayo po, ayaw mong may kalaban. So, magfa-file ako ngayon sa Zamboanga City ng rape. And then later on, bibigay ako ng maling address. So, kapag nagbigay ka ng maling address, so the prosecutor's office will have to resolve the case. Bigla kang may warrant. Bigla kang ngayon, ikukulong ka ngayon, magtatago ka, hindi ka na lalabas mga kampanya. And totally it's fabricated. Wala naman talagang rape na nangyari. Pero yung mga allegations nandun. Maglalagay sila ng victim na peke, ang pangalan. Pag binerify mo, walang mga taong ganun. But the point is that, in the meantime, you were already prejudiced. Hindi ka na nakakampanya.
Chair.
Continue.
How does this relate to Article 184, offering false testimony in evidence? So hindi ba, for example, yung prosecutor ba pwedeng ma-charge dito? Well, you offered as witness a rape victim, hindi pala victim. You didn't do due diligence.
I think, Your Honor, the concept of the amendments is that even before trial, mere filing of a fabricated information is already penalized.
This does not pertain to. This doesn't contemplate false testimony. It's false initiation of a complaint. Initiation of a complaint. But let's hear from.
To initiate a complaint, di ba kailangan merong testimony? I mean, it has to be based on some
complaint
sort.
affidavit lang.
Pero kailangan may ebidensya of some sort.
Be attached to the extent available. I-attach sa complaint. But can we hear from Justice Ampuan?
Maganda yung tanong ni Congressman Tino. Paano nga dahil based on reasonable doubt ang conviction natin. At pagka hindi reasonable doubt, pagka reasonable doubt, acquittal. Ngayon, kung totoo talagang na-rape, pwede bang kasuhan yung nagkaso ng rape dahil na-acquit? Yan ang tanong niya.
Opo.
Paano yun?
Si Kong Dumogan would like to
Ito may
respond.
rape.
Akin, not exactly. Because as you pointed out, Justice, well, based on reasonable doubt, di naman fabricated complaint. What we are referring here is obvious na fabricated complaint that will result to the filing of an information that carries a penalty higher than the perjury case existing. That's the situation here. In the particular case, well, na-acquit based on reasonable doubt. I mean, to say talagang because kahit ito, subject to the final judgment of the court. Kung reasonable doubt yung acquittal ay hindi kuhan.
Pero if you look at the sequence of events, so there's a false complaint, right? And then there's the information filed in court. And there's a warrant of arrest. At that particular point, you're still missing elements of the offense, which is that you still need to be acquitted. Diba? So, if the acquittal is based on reasonable doubt, and failure to prove guilt beyond reasonable doubt, ang sinasabi po, I'm just recapping. Ang sinasabi parang, okay, you won't be liable under this article because there's still some basis. Yun sinasabi niyo, di ba? Oh, tama pa. But let's hear from Attorney Binang.
Yung yung difficulty po kasi is magkaiba tayo ng pinanggagalingan. On the one hand, it's very clear to us na yung example kanina, completely fabricated. So it's easy for us na pag ginawa mo yan, okay na. But if you look at it, yung process by process, inevitably, dadaan ka sa judicial trial, magkakaroon ng acquittal. Tapos yung acquittal, hindi naman niya sasabihin na, uy, these are grounds for false affidavit. It will not say that. So the question of Congressman Tino is merited. When there is an acquittal in a criminal case, is that grounds for this? And as written, there is. Now we're talking about abstracts, no? Na meron ka namang basis, baka na-rape ka talaga. Of course, but we will not be in all rooms where this will happen, and this will be weaponized. As written right now, as long as there is an acquittal at the end of it, I can charge you for something. And meanwhile, while you're not adjudged as being guilty of that, hindi daw fabricated, dumadaan din sa proseso yung biktima ng remember, the penalty for this is reclusion perpetua also. If you falsely impute a reclusion perpetua crime, you're going to be charged with a reclusion perpetua crime also.
May I provide an example and see if it's on point?
Yes, sige.
The example is this, a rape case. There is no denying that there was contact, sexual contact. There was penetration.
Okay.
So it boiled down to a question of like whether the victim consented or not.
Yes.
And then the victim, it was proven at trial that that she consented,
yes,
for which she was acquitted. Given those facts, will the person be liable under this article?
If I am a person who's vindictive, I was the one accused of the crime.
You would?
I would charge. Yeah, precisely. But you're also putting that victim in the position she has to defend herself, be behind bars, because the offense is non-bailable as well.
Mr. Chair, well, possibly that can happen. But take note, if let us say the accused who was acquitted based on reasonable doubt, as shown in the example, will file a complaint under this one. I do not think the prosecuting or the prosecutor investigating the case will not will charge him under this provision, because in this one it's very obvious that it says fabricated complaint. In that particular case, acquitted, na nakalagay dyan na it's not by force but it's consensual. Because again, this one, subject to the final determination of the court. And the court did not say, it's not just based on reasonable doubt, it did not dispute that is a fabricated complaint.
Mr. Chair.
Let's hear from...
Mr. Chair.
I think that's Attorney Bilang and then Prosecutor Custodia. Because they were...
Yun lang siguro, I've been voicing out my concern regarding this, and medyo paulit-ulit na ako, but I recognize where the evil that we're trying to solve by putting this provision. There's no denying that. There is a danger. So, insofar as there are false imputations of a crime, should we criminalize it? Yes. But siguro yung reservation ko lang po to the penalty. The threat that I can be meted the same penalty as reclusion perpetua din, baka hindi. Kasi again, I pointed to the example. And umupo na ako sa korte sa witness stand, sinabi ko na siya may gawa, siya talaga. Na-convict siya for final judgment. Reclusion mayor pa rin yung penalty ko. Pero yung oath, yung complaint affidavit, reclusion perpetua yung magiging penalty ko doon.
Ito yung sinabi ko kanina, yung false testimony by the criminal complainant is actually as pithy and weighty as the criminal complaint, the initiatory complaint. Yun yung sinabi ko kanina. Tapos babalangkasin ko sana yung may ibang katanungan, and then nakalimutan kong balikan. Kasi naunahan ako ng mga usapan. Na, di ba, I was about to poll on I broke down the questions of like, who's in favor of criminalizing itong perjury committed through the execution of fabricated criminal complaint, affidavit, or sworn statement. That was the first question. The second question would have been, who's in favor of imposing the same penalty? The third question would be, who's in favor of criminalizing perjury through the provision of a false address? And then the fourth question is, who's in favor of imposing the same penalty as the underlying offense? Yun ang apat na tanong tatanungin ko sana mag-show of hands O Kong Tino.
Yung complaint affidavit ba does not fall under perjury, possibly fall under perjury as well?
Pero ang sinasabi po ni Kong Dumogan, he's not criminalizing all perjurious complaint. No? Let's put it there, perjurious complaint affidavit. He's only criminalizing perjurious complaint affidavit where the underlying penalty is more than prison mayor. Yun ang sinasabi niya.
Pero just to clarify, so if you file a fake, false complaint, pwede ka nang ma-charge ng perjury.
Correct.
Pwede na naman pala eh. Ang gusto lang ni Congressman Dumogan, itaas or gawing equivalent to the...
Kasi yung...
The fabricated complaint.
Kasi...
To the penalty for the fabricated complaint.
Yes.
Because ang pananaw ni Kong Dumogan is it's one thing to perjure yourself by submitting an affidavit that is required. No, it's completely another thing to file, to a criminal complaint, a false criminal complaint. Yung parang kasi the inconvenience and the prejudice to the falsely accused, falsely accused, but Prosecutor Cristoria.
Thank you, Mr. Chair. I see the point of Congressman Dumogan, Mr. Chair. In his proposal, there is already the crime of perjury.
Yes.
And it is by way of a fabrication of a complaint, affidavit, or it is only the penalty.
The penalty. It's only the penalty.
So the crime of perjury is already committed.
Yun po, penalty talaga pinag-usapan dito.
But my only reservation, Mr. Chair, is the repeated mention of the misaddressing. Because it will always pass the test of materiality. So even if you put the wrong address and the charge, again, I would mention the charge again is estafa, that would fail the test because that is not material.
Maybe
to the main issue.
it's for a different provision, but
yes,
not here. I'm sorry. Let's hear from who is your spokesperson on this side of the table, on this side of the room. Prosecutor Nohara.
Okay, Your Honor, we are one in saying that if you file a complaint, criminal complaint, and it turns out to be false, that is perjury. Perjury na siya eh. Can we just make it this a qualifying aggravating circumstance? So when it comes to criminal complaint, one degree higher. Because we are treating it differently. Wala nang equal protection clause dito. Kasi what's so special about a criminal complaint? So anyway, it's perjury. Can we just consider it as qualifying aggravating by imposing a higher penalty? At may makakaroon tayo ng sort of agreement o ganon.
Wishful thinking po yun.
Kaya nga po, sinasuggest ko na. Kasi baka umabot tayo ng 5:00 rito, di ba?
Wala po kaming pamerienda, ha? Hanggang kape na lang. I guess, trying to get sense. Ay, may paparayin kay Prosecutor Horda. Jordan.
Your Honor, please, I would just like to bring your attention to Article 172, Paragraph 1, penalizing affidavits that constitutes falsification. And the Supreme Court has consistently held that the following elements must be present. Offender makes statements in narration of facts. Offender has a legal obligation to disclose the truth. Facts narrated are absolutely false. The offender deliberately made untruthful statements with intent to falsify. Other than perjury, he has another liability, which is the Article 172, Paragraph 1, which is committed by a private individual. Falsification of private document
Did you read, ma'am, Article 171 first? What was the first
Article
article?
171 refers to public officers
Public
committed.
officers
Yes, but
falsifying.
172 refers to private individual.
So you're saying that
That this case could also be, recourse could also be under the falsification.
okay.
For false address.
Also in addition to libel.
Yes. If there is untruthful statements, like for example, the address, then that would fall under Article
Part
172.
na lang natin to for the Mother Committee.
Mr. Chair, well, I do not care whatever it will fail. Our concern is look, and I hope we take this one. If you file a fabricated complaint that carries a heavy penalty, higher than what perjury provides or falsification will provide, then it should carry the penalty for that fabricated offense. That's all that we are asking. As pointed out earlier, we agreed that perjury is already an offense. It can be considered also under the falsification, as you said, but I'm trying to emphasize is, if you file a fabricated complaint that resulted to the filing of an information which carries with it a heavier penalty than the underlying offense, then the penalty imposable should be the penalty for the underlying
Are you amenable, Kong
offense.
Dumogan, to special aggravating circumstance 1 degree higher? Because in other words, kung prisyon mayor ang base mo, then ano ba yung sa una? Minimum? So, 1 degree higher is medium. Hindi ba large? Hindi, loko lang. Prison mayor medium. Okay. Are you amenable to that? Prison mayor is 6 to 12. 6 to 12 yung prison mayor eh. So, it's somewhere in the middle. That's no longer bailable, ah? I'm sorry, bailable siya, non-probationable. Non-probationable, sorry. Tama. Sa bagay, no? Both are not probationable.
So, ako okay naman ako doon. But, ang question ko lang is, kasi parang yung concern ni Congressman Dumogan is, may false complaint na final, tapos an information was filed.
It was filed and then resulting in acquittal.
Resulting in trial na, basically.
Trial and then acquittal because it was baseless.
Pero, wala bang, kasi sabi, patently false. Okay, fabricated. Hindi ba dapat sa prosecutorial stage pa lang, preliminary investigation, kung obviously fabricated
That would have been caught right there.
Hindi nyo ba kayang,
Mr. Chair.
Hindi ba,
Mr. Chair.
dapat may ganun.
Mr. Chair.
Para maraming ganyan Sabi nga, harassment cases.
Mr. Chair. Sandali lang po. So, let's hear quickly from the author first.
Mr. Chair, that was already been answered a while ago. The answer was here. You filed a fabricated complaint, then giving a false address. So the respondent was not notified to file a counter affidavit. So yung basis lang ng prosecuting fiscal or prosecutor, the evidence submitted.
Let me ask a question, Kong Dumogan.
Yes.
What if, of course, at the trial stage, I'm brought before the court. I'm the respondent, now the accused, right? I would have the opportunity to say, move for preliminary investigation because it was served on the wrong address.
Your Honor, there is a rule under the rules of court that you can file a motion for investigation within 5 days from knowledge of the issuance of the information.
Yeah.
In the meantime, when will be the first time that you will be able to learn the filing of information?
Warrant of arrest.
I suppose when you are already arrested.
Yes.
Okay. So, once arrested, you have that 5 days. But if you cannot avail that 5 days, the trial will proceed. Not all of us had a ready access or have a ready access
Yung
to.
akin lang po, okay, I see the point of that. My only, again, it's the proportionality of the penalty.
Okay.
Because now you factor in the passage of time. The passage of time. When you're out there, you didn't know about it, hindi ka mahuhuli. You're still free.
Yeah.
You're served a warrant of arrest, you're apprehended, now you're looking for a lawyer, right?
Yeah.
And then you talk to the lawyer, attorney, hindi ako nabigyan na ano kasi ano. So you're brought before the court, right? At some point. At that particular point, let's not talk about motion for investigation. You will tell the court on the first opportunity you're presented in court that you didn't get a copy. Di ba gano'n ang anong gagawin ng court?
Yes,
Almost always, by experience, Mr. Chair, the court will grant the motion and will refer back the case to the prosecutor. Yun nga po.
But Your Honor,
but when the court grants the motion,
it should be within
you
the
will be
period.
set free.
No, Your Honor, it should be within the period.
What if?
Kasi kung lumampas ka doon, more or less the court will deny it.
Of course, but you will have. Okay, you have 5 days.
The
Basically, if you
earliest-
didn't file it within 5 days, you sat on your rights.
Yes, Your Honor. The earliest that you can assert that defense is that during the cross-examination of the witnesses of the prosecution already. In the meantime,
he's already
if you have no
detained.
money to bail out yourself, then you stay there.
Okay, so that's one. But but still you get to kailangan umabot ng may acquittal, no? Final acquittal. Again,
Mr. Chair.
Prosecutor Cristoria.
Just to the point raised by Congressman Tino, the prosecutors are supposed to evaluate. Yes, sir. Purposes of discussion, Mr. Chair, if I am the accused, that would somehow be in my favor because that would somehow weaken the case because my case is supposed to be fabricated, but it passed through the evaluation of the prosecutor. So somehow the prosecutor found merit in my complaint. Somehow that would weaken the case of the complaint of the one who is complaining that the charges are fabricated. That would weaken his case, because I could argue that that was evaluated by the prosecutor.
So, but just to clarification, because if the witness if the respondent was subpoenaed, no, was subpoenaed. In other words, told to submit a counter affidavit, right? Then, the concerns about whether it's baseless or not will be addressed by the fiscal, right? Kasi reasonable certainty of conviction, di ba? So, as I see it, the only way, I think, yung service on the wrong address or the false address is elemental. Is an element of the crime. Element po ba? So hindi or, end. Ano ba yung wording? It has to be end.
Actually, you're correct. The first one is end. On it, yung sinadjis nga, ni Secretary Vida, which is is instead of end or, we can
Are you amenable to end po? And you're also amenable to
end what?
so execution of a fabricated complaint and service on and knowingly providing the false address.
Yes.
So yung false address is provided by the complainant?
Yeah.
Yes.
Yes.
And the
the
prosecutor will...
Yan, magandang tanong yan. Go. Sige.
Okay.
Alam ko na pupuntahin. Sige.
Hindi. So, yung address kailangan manggaling dun sa... paano kung di mo alam yung address? Or it's the last known address na hindi na yun yung address?
Prosecutor Camora.
Yes, Your Honor. Usually, it is now in the form of affidavit, and usually they will allege there that this is the last known address.
Yes.
Now, there are instances in my experience as a trial prosecutor, Your Honor, wherein a person has this address, and then later on, the neighbor inform him that somebody will file a case against him. He will transfer residence. So definitely, insofar as the complainant, that address, the previous address, is known to her. But when the case was, the complaint was already filed, the respondent has already changed address. Because there is no obligation on the part of the respondent to provide this address. That is the burden of the complainant. So precisely, last known address would be sufficient to us. And it's up for him to refute. For after all, he has remedies, just like the reinvestigation or motion for reconsideration. Those can be raised.
Although, if you're saying you provided a false address, as a complainant, with the wrong motivation, what I will do, I will just say last known address.
Yes, but definitely, if you want to charge him, we should make an element knowingly.
Knowingly, right? Okay.
Felonious, maliciously.
Okay. Now,
Provided the wrong address.
Is there any kind of due diligence that prosecutors exercise to vet the address information?
Your Honor, we do not know who is the accused. We do not know the whereabouts of the accused. We only rely on data provided by the complainant, Your Honor.
Okay. Other thoughts? Kung tingin meron ko sabihin, okay na. So, Prosecutor Nahara,
yeah, I would like to just emphasize that this crime, just like falsification and false testimony, are all what? Mala insect crimes.
Yes.
So the specific intent to pervert the truth is material. So if it is not, there's no specific intent to pervert the truth, there's no crime. So it is very hard to determine at preliminary investigation stage to determine whether or not there is malice in the imputation or the false address, for example. So if the complainant or the respondent merely use the last known address, there's no malice in it. So how can we prosecute perjury there? Because in that case, it is a matter of defense that can be taken up during the full-blown trial in court. But for purposes of determining the prima facie evidence, uubra na yon. So kawawa naman yung mapapaila ng kaso.
So in favor of having this paragraph?
Not actually. To be candid. That's why I'm proposing that we can just treat this as a qualifying aggravating.
Yun nga po.
Kaya nga,
No, so there are two things. One is we now know that the two elements. No, that one, the false affidavit, the false complaint, and the false address. Hindi na all yun. Second, the question now is, it has to be knowingly, the question is, okay po ba yung special aggravating circumstance, 1 degree higher na lang? Tingin nyo. See Attorney Bilang, you were raising your hand?
Me, I can somewhat agree to what the body will say, but I'm so concerned because I've been handling cases that the result of a fabricated complaint is an unbailable offense that resulted to the detention of the accused 4 years and 3 months, 1 year and 9 months, bago it will be resolved. And result to the exoneration of the accused. Now, you file a perjury case or falsification, a bailable offense. But the accused had already suffered. That's my apprehensions here. That's why we filed this one.
Should we agree on? Should we make it more specific by perhaps before I ask for a show of hands, by throwing in the word knowingly when the perjury is committed, as presently worded, when the perjury is committed through the execution of a fabricated criminal complaint, affidavit, or sworn statement, falsely imputing the commission of a crime upon another person, and providing a false address. Huh? False. But may false information. False. Teka. False address of the person falsely imputed. Ito to. Yan. False address of the person falsely imputed in connection. Huh?
How is that proven?
Teka. And lang yan. So again, let me read. When the perjury is committed through the execution of a fabricated criminal complaint, affidavit, or sworn statement, falsely imputing the commission of a crime upon another person, and by providing a false information or false identifying information of the person falsely imputed in connection therewith. Ito, the penalty prescribed by law for the offense falsely imputed is higher than prison correctional in its minimum period. The penalty to be imposed shall be equivalent. Need equivalent. Next higher. The penalty shall be prison. Why not just say it? Prison correctional. Prison mayor in its medium. Is that acceptable to you, Kong Dumogan? Huh? Can we get a show of hands? Oh, I just read to you the revised wording. Okay. Who's in favor of that? Any who's in favor of that? Please raise your hand. Okay. 1 degree higher.
12, 13, 14, 15, 16, 17 po. Majority.
Yung COMSEC yata, nagtaasan din ng kamay eh. Bininang mo yata, recount nga. Dilo ka lang. Okay. So we will present that to the Mother Committee. Hopefully, we get their approval and not. Okay? O, nakakatatlo na tayo.
Kanina yung assignment.
Can we talk about assignment now?
Yung mga assignment. Balikan niyo po. Kasi dito si Alpo Film.
Offering calls.
184. Offering false testimony in evidence. Sige nga, maikli lang to eh. Ha? Ano ba naman yung 2 oras? Offering false testimony evidence. Any person who shall knowingly offer in evidence a false witness or testimony in any judicial official shall be punished as guilty of false testimony and shall suffer the respective penalties provided with. So there's a reference back to articles that we already agreed upon. How is this different from yung sa in the Article 184 of the Revised Penal Code? I'm just trying to see what the difference is. Huh? How is 184? Teka, naputol yata yung 184 natin.
Ako lang gusto kong muna humingi ng clarification, Chair. Kanino mag-a-apply to?
Presenter.
Yes,
the
person
presenting, this is presenting a lying witness, so it would be the lawyer,
the prosecutor,
the litigator. Prosecutor, sir. Pero kanina mo pa yung prosecutor po. Yes po. Prosecutor.
Kasama rin.
Yes po.
So, this is parang ito yung safeguard dun sa, kasi kanina dinidiscuss natin yung false testimony.
Yung witness yun.
Diba na ang habol mo? Kasi we were discussing Hintay mo pa ba ang final judgment? Okay, so parang ito yung safeguard against offering false testimony. Kailangan tiyakin tuloy ng prosecutor, i-vet niya muna. Di ba? Di ba ganon? Tama ba?
Your Honor, just to respond to that. Before we present evidence, Your Honor, we have to talk with the witness. And almost all, you cannot really determine if he's telling the truth. Because there are witnesses, before appearing to you, they have already mastered their statements. They are spontaneous. Their behavior is okay. More or less, the prosecutor, halimbawa, public prosecutor cannot determine. So, later on, you only discover that he is making falsity when he is being cross-examined. In that case, you cannot charge this under this provision.
But I think this is ambitious, because it says that if you knowingly offer in evidence a false witness, in other words, you
must be in cahoots with that.
You have to be in cahoots. You
Yes,
have prior
Your Honor,
knowledge.
you must be in conspiracy
almost
with
like
that
suborning perjury. Almost, no?
Witness.
Suborning perjury, almost. Subordination of perjury. Where you abet or encourage somebody to perjure.
Yes, Your Honor.
Ganon yan eh. Parang ganon. Yeah, subordination of perjury is actually a crime. And also, this applies not just to prosecutors. It could be also to defendants, counsel for the accused, counsel for defendants.
In any proceeding yan.
In any proceeding. Ngayon, how is this? Teka, tinitinan ko lang eh. But they vary in length. Ano bang, what's the difference? Naputol ba to?
Naputol eh.
Naputol. Okay, shall be punished. Okay, I see. So, there's no okay. Any objections to this? None?
Huwag na kayo mag-object.
Going once, going twice?
Well, ginugol ko lang, Chair, kasi nakalagay dito, Republic Act number 11594, strengthened punishment against dishonesty in legal and official settings. So, kanina, someone mentioned this, na, di ba, may special law?
Is that the amendments increasing the penalty? I think that is...
Increasing. So, take into consideration na ba yun, Chair?
The RPC actually already enhanced the penalties.
Okay.
But here's a question. What is the difference between offering evidence of false witness? Okay, what is a false testimony? Because it says or.
I will answer that, Your Honor. I was supposed to raise my hand.
Okay,
in false testimony, the offender is the witness who testifies. But the one who is utilizing him, kunyari, accused or the prosecution, that is the crime under Article 189, offering false testimony.
Yes.
The mere offer of a false affiant is already a consummated crime of offering false testimony and evidence.
Well, no, I get the point, but it says offer in evidence a false witness or testimony. Why is there a distinction between a witness and a testimony here?
It's a matter of style lang, but it pertains to false testimony.
Witness.
Yeah, false witness.
Okay.
So the false witness is the person testifying falsely.
Nothing
but
to do
the nature
with...
of his testimony is false. So that's the distinction there.
Is there nothing to do with offer of evidence or anything like that?
Yes, because we know if we present a testimonial evidence, we make the offer first. So the mere offer is enough to consummate this crime.
Yes.
The false witness need not actually testify.
Okay.
So the intent is really parang to deter anyone from even offering, di ba? So yun yung intent.
Correct.
Para hindi na ma-introduce sa court.
Yes. Kong Domogan, you wish to speak? And then Attorney Bilang.
Of course, this is not an easy offense to prove. Because first, you have to prove that the testimony is obviously false. Now, it's banking on the result of an appreciation that it is false or not. It's not an easy question to address.
And also prior knowledge of false.
But, well, that's what the law states. But actually, this is not an easy offense to prove unless it's obvious. Again, going back to the same proposal, as obvious na it's really false, yet the counsel, either for the defense or the prosecution, will offer it, because now we change the procedure now. As pointed out, before a witness is presented, you have to offer already the testimony of the witness. Unlike before, the old procedure, let the witnesses testify. After they have testified, that's the only time when there will be formal offer of evidence that you will offer the testimony of the accused.
Your Honor, so far as testimonial evidence, you have to offer it even before taking the testimony. But if it is documentary or object evidence, Your Honor, only after the presentation of evidence in chief, Your Honor.
Under the old procedure, it's only after the testimony that you offer even the testimonial evidence. But as I said, now, if it is testimonial, it's part of the procedure that you have to offer first.
Before they sit.
Before you conduct examination.
By the way, the offer of evidence is an opportunity.
Sometimes, Your Honor, there are object or documentary evidence. It will all depend on what kind of offer are you going to make. Sometimes a documentary evidence and or object evidence, the parties would offer it as part of the testimony of the witness.
But this contemplates the person, no? By the way, the offer of evidence is an opportunity to coach the witness also. Attorney Bilang.
No, just wanted to add that perhaps it's better to retain witness or testimony to cover also those instances where the offer is for depositions. You're not necessarily offering the witness, but the testimony only.
Yes. Good point. So we are, Prosecutor Nahara?
This 189 pertains to false witness or false testimony. But according to Supreme Court, the drafters of this revised penal code forgot to include a provision on subornation of perjury. So that's the loophole there. Subornation of perjury is refers to a person who induces another to execute a false affidavit.
Isn't that penalized now by the revised penal code?
Yes, but as a principal by inducement. So the principal, the person principally liable for perjury is the one who makes the false.
Who perjures?
Affidavit. But the one who is inducing or coercing him to testify, to execute false affidavit is not penalized. Napipenalize lang siya as being a principal by inducement. So there's no particular article on subornation of perjury.
But do we need to rock the boat, given that it's also penalized as a principal by
inducement? Yes,
but
loophole nga siya. Binigyan na lang siya ng Supreme Court ng criminal liability because he is inducing another to commit to execute a false affidavit. Meron po tayong offering false testimony. Counterpart yan doon sa false affiant. False testimony. Wala tayong counterpart on that false affidavit. That's why I'm just suggesting a particular article, or maybe we can include this here in Part 1.8, the subornation of perjury.
Attorney Bilang.
Just wanted to point out that I think there's a pending bill for this. In one of the hearings before, we were given a copy of this, a pending bill by Conchel Jokno about subornation of perjury.
What is it saying?
I don't have the copy right now. I'm sorry, but we can, if we want to include that, perhaps we can. Yes.
We can refer to that. So, okay, but for now, we will adopt this as is, subject to the discussions on proposed revision of Conchel Jokno. Nakatatlo na tayo. Tatlo na ba yun? Apat.
So, essentially, ano na bago?
Wala. We are now on... Kaya niya pa? Can we still go? Are you still good?
Sir, we have to travel from Quezon City to Quezon City. The problem is that umulan kasi, Your Honor.
And then,
kaya baka may baha dyan sa ano.
And then,
others, our colleagues here will be traveling to Mindanao and Cebu, Your Honor.
okay, so given the lateness of the day, we will suspend consideration of the bill, and then we'll be notified on the next meeting. In the meantime, I know that there are submissions here. Ano ba to? Sino nag-submit ito?
Monopolies and combinations in restraints of trade. Maganda to. Next.
Submission from the BSP concerning counterfeiting. We will revisit it first thing, next week. So, So,
Chair, ang next ba, tama ba, ay monopolies?
Itong sa
Anti-trust, parang ganon.
Hindi pa.
In restraint of trade?
Yung mga submissions nila, there's...
Excited na ako sa monopolies in restraint of trade
And also for the monopolies in restraint of trade, when we get to that point later, invite the Philippine Competition Commission. Okay. So we will suspend consideration of these House measures until further notice, and you will be notified accordingly. I trust that everyone has submitted their homework. Is there any pending homework? None? There being none? Okay. I'll see you next week. Thank you.
Guest provision yun, sir.
Thank you.